Lordship starts at page 25. 22 and all is the index, etc. I'm grateful, Lordship. Lordship, on page 1 of my present written note,
increase the cooling, otherwise for everybody it will be very fast.
Sayyid Altamash Nizami, who is one of the Pirzadas of the Hazrat Nizamuddin Dargah. Lordship, the reason why we were constrained to file this intervention application was because a writ petition came to be filed in the Delhi High Court pursuant to the judgment in the Sabrimala case by a five-judge bench of my lords. The writ petition said that the petitioner was a law student who came to Delhi for internship, happened to visit the Hazrat Nizamuddin Dargah, and there was stopped from entering the so-called, so to speak, sanctum sanctorum, the small enclosure where the grave itself is housed, and said that that was a violation of her Sabrimala declared rights. And therefore, the High Court was asked to pass a writ prohibiting that the practice of prohibition of women for their entry inside the sanctum sanctorum of the holy Dargah of Hazrat Nizamuddin Aulia is illegal and unconstitutional. So the question that my ladyship has been asking, that a complete third-party interloper non-believer should walk into a religious place of worship and demand that all matters of faith yield to their whims and fancies. This is the starkest example that is possible, where a law student says, I came for internship, I wanted to enter the sanctum sanctorum, and I am being stopped, and this is a violation of my Sabrimala declared rights. Lordship, just by way of background, a Dargah, Lordship knows, is a place where a saint is buried. While there are sharp divisions within Islam on what is the status of persons who have passed away and saints who have passed away, but insofar as the Sufi system of belief is concerned, there is a lot of reverence which is attached to the place of interment of a saint. Lordship, what is also important is I want to mention that the learned solicitor said that in the context of the Ajmer Dargah and the Hazrat Nizamuddin Dargah, that everybody goes there, therefore it is not a religious denomination in that sense. While I'll come to the question of religious denomination later, but I just wish to also point out that while Dargah committee was decided on the assumption, without going into the case of whether or not it amounts to a denomination, they said we'll assume and proceed. But Devaru itself had held, my lords had held, that the mere fact that other persons, non-adherents, are allowed to enter doesn't take away the denominational character of a place of worship. So, Lordship, the Sufi silsilas, the Sufi systems and the Sufi system of belief, there are four major systems in India: the Chishtiya, the Qadriya, the Naqshbandiya, and the Sohrawardiya. This is the Chishtiya silsila. Lordship, the system is, first I wish to point out, definitely a religious denomination, because if you read the books, for instance, Fawaidul Fawad, which is the sayings of Hazrat Nizamuddin Aulia himself, there is a lot of emphasis on following the practices of Islam. So, Roza, Namaz, Hajj, Zakat, and first of all, of course, faith, Iman, all of them are sine qua non of being a Sufi. And in addition to that, certain other esoteric practices by way of devotional and spiritual means of attaining the divine are prescribed in addition to and not in derogation of the main core. So it is very definitely an Islamic school. And to enter a Sufi silsila or become part of a Sufi silsila, you have to take bay'at, which is an oath of allegiance on the hands of a sheikh who is permitted to take the system forward. And so in that sense, it has a rite of passage. So a religious faith which has a rite of passage in the sense in which the word denomination has been understood is very much a denomination for purposes of Article 26. And while I have something to say on denomination for Article 26, I'll come to that later.
Just a minute, would you set your argument on a higher pedestal that a dargah is basically a Sufi type of a institution?
Lordship, please.
All dargahs are under the Sufi tradition. Now, Sufism itself is a denomination and any section thereof. So all the individual dargahs become sections thereof.
I'm grateful, Lordship. Lordship, so
the language itself would
grateful, Lordship. Lordship, in fact, for purpose of Article 26, my argument will be, and I'll come to that later, that because it includes denomination or any section thereof, no religious institution or place of worship will be left without the protection of Article 26. Because if you take the view that some groups and schools amount to a denomination and some don't, that leads to the absurd consequence that some places of worship have no right of internal management and some do, which is not the purpose of Article 26 at all. And I'll come to that later. But I'm very grateful for my Lord's question. I'll answer it when I address that issue in turn, if my Lord's permit. Lordship, so therefore, a Sufi silsila is very much a religious denomination, even as presently understood pursuant to my Lord's judgments. Lordship, an argument that Mr. Giri made, I just want to emphasize that a place of worship cannot be separated or segregated from the faith or belief attached to it. That piece of land in Hazrat Nizamuddin Basti is nothing if not the Dargah of Hazrat Nizamuddin Auliya. So to say that it exists in any dimension other than the faith that exists around that place is to misunderstand the concept of a place of worship or a place of religious significance, because if you don't take the faith as you find it and have an objection to the faith itself, then what is that place to you and why are you there are questions which automatically arise for consideration. Because Lordship, if the right of a person under Article 25 and 26 is to be made subservient to the right of a tourist or a passerby or a curious onlooker to take a walk, Lordship, then it makes a mockery of Article 25 and 26. Because it's not as if it is a place of, like, there is a denial, for instance, what Article 17 contemplated, that public wells, places of any kind of public resource, etc., are being kept aside for only one caste, community, gender. It's a belief system, and that place of worship is nothing but the belief system. There is nothing more to it. And that same goes for the Sabarimala temple. It's just a hill, if not for the fact that there is a temple of Ayyappa there. So, Lordship, therefore, when that right is demanded, that I should be allowed to go on a whim, because it's nothing more than a whim, then to reduce that right to subservience to a whim is to make a mockery of Article 25. That's my first point. Therefore, Lordship, my conclusion in paragraph 8, that therefore a person who does not share the belief has no constitutional entitlement to enter a place of worship on the basis of a claimed right to equal access, and certainly cannot invoke PIL jurisdiction as a vehicle to subserve these whimsical desires. Lordship, this is insofar as non-adherents are concerned, which is the question that my ladyship had been. I'll move then to what is the status of adherents in the course of my argument. Lordship, on the first, because the seventh issue automatically stands answered with these submissions, Lordship, on the locus standi of a person who doesn't belong to the community. Lordship, on the first issue, which is the scope and ambit of Article 25, Lordship, if Lordship will just have my written submissions, and this is the history has already been shown to my Lord, so I'm not repeating that. But just for the visual aid, if Lordships may have, page 33 of my original written submissions at volume Roman 1 point numeral 3.
There you have reproduced the different texts which were proposed as.
That's right, Lordship. So just as a visual aid for ready reference, if Lordship has that table, Lordship sees that in the first two boxes in that table, the present Article 25 subclause 2 exists as an explanation.
Maybe probably you have, what you want to say, you have summed up in 17.
Lordship, and therefore, Lordship, the argument itself I've made in my new note, that Lordship, what was originally crafted as an explanation, and Lordship, that's also an aid to its understanding. Because in principles of statutory interpretation, an explanation has a certain ambit and a certain role. An explanation cannot take away from the main section what is not there, what is there in the main section. It cannot add to the main section what is not there in the main section. Therefore, it can only explain parts of the main provision itself. And Lordship, what I'm pointing out is I've gone through all the debates surrounding the evolution of Article 25. The conversion from an explanation to a subclause was merely an exercise in renumbering with no debate or discussion. Therefore, it doesn't seem that there is some thought behind that it is now to be elevated to the status of article of a sub-article. It was merely renumbered at some stage, some latter stage in the course of its crafting. It was always contemplated as an explanation to the main article. And today, Lordship, if we see it as an explanation to Article Subclause 2, as an explanation to Article Subclause 1 of Article 25, Lordship, that throws light on the meaning and the scope and ambit of Article Subclause 2, because 2A, which is the social, political, financial, and secular activities, will be an explanation to religion by defining what religion is not. And I made that argument in my written submissions of essentially religious and essentially secular, which has already been made, so I'm not repeating that. But Article 25, 2 subclause A, which is regulating or restricting any economic, financial, political, or other secular activity which comes to be associated with religious practice, is defining what religion in 25.1 is not. Therefore, what is essentially religious is in 25.1. What is essentially secular is dealt with by way of explanation to say that therefore that is not squarely covered by the protection of Article 25.1. Lordship, and the second part, 25.2b, will operate within the ambit of the power which is already given in 25.1, which is public order, morality, health, and other provisions of this part. Therefore, if there is a concern of public health, how will that concern be introduced into the law? It will be by way of a law by the state, and social reform will therefore be colored by one of these four. Social reform cannot be anything other than one of these four. So social reform as anything outside of either public health or morality or public order.
Bit difficult to accept, we note it down.
Lordship, please. Lordship, for the reason, because otherwise social reform is an absolute power with no checks and balances in the Constitution, which is antithetical to our understanding of the Constitution. Therefore, Lordship, to see it as an explanation, therefore, 2A then qualifies public order, morality, health, and other provisions of this part, that under these heads, the state can pass laws on reform or social welfare. So, Lordship, therefore, in my submissions, I have cited judgments on statutory interpretation of an explanation to say that it cannot take away or it cannot add something which is there not in the main section, because this was simply an exercise in renumbering. Lordship, now, I come now to the essential religious practices test, which has come to also be read into Article 25.1, because the first issue deals with the scope and ambit of 25.1. Lordship, if in Justice Iyengar's judgment in Sada Sayyidna's case, Justice Iyengar reads essential practices as what is impervious to even social reform. Therefore, in his understanding, essential practices was an additional level of protection, that your religious practices are protected, but your essential religious practices are not even subject to social reform under subclause 2. So what was originally being seen, of course, in origin, it was essentially religious and essentially secular. But when it started becoming essential religious practice, one of the first statements of that, one is, of course, Dargah Committee, which we are all questioning. And the other was Justice Iyengar's concurring opinion in Sardar Sayyidna, where he says, what is essentially religious is impervious even to power of social reform, because in the name of social reform, you can't take away the core of a religion and the identity of a religion. And for this, Lordship, the one example that comes to mind is that of self-flagellation by Shias during Muharram. Nobody can say that self-flagellation is not contrary to health. But it is for the state to decide on a policy prescription whether this requires interference on the ground of health under 25.2a, read with the health, or being core to the practice of the persons who do it, because the entire schism in Sunni and Shia Islam was around the battle of Karbala and the 10th of Muharram, and so that is integral to the Shia faith in that sense. So therefore, in Justice Iyengar's understanding, that is impervious even to social reform, because it is an essential practice. So all practices are protected, but some practices are outside the reach of the state, is how Justice Iyengar reads Article 25, and I commend Justice Iyengar's view to my lords for acceptance, that is the understanding that co-religious practices are outside even the purview of social reform on the grounds of public health, morality, public order, or other provisions of this part. Now, Lordship, I come to the interplay between 25 and 26. Lordship, here I just wish to point out that 25 and 26 have been used in the latter judgments almost synonymously, as if this is a practice is sought to be protected, saying this is my 25 right and my 26 right, without really an attempt to make a distinction between 25 and 26. Lordship, there will no doubt be an overlap, but in my humble submission, the degree of overlap between 25 and 26 is far smaller than it has come to be in the course of latter judgments, because 25 protects religion and religious practice, and 26 protects the right to manage affairs in relation to religion and religious practice, which is in one. So the practice is in one, the right to manage affairs in relation to that practice is in two. And therefore, while there will be an overlap, but the overlap is not as large as it is made out to be, because anything will either be a practice or will be the right to management of affairs in relation to the practices. So for instance, Justice Bagchi gave the example of cannibalism or mass suicide. While there has to be a policy prescription and a right of the state to control something like that, but Lordship, that automatically comes into the domain of practice. So in my humble submission, something like that is not within the domain of management of affairs in relation to religion. If you are prescribing that everybody commit mass suicide or that people engage in cannibalism, the practice itself is the focus here, and the practice is covered in 25(1), and therefore subject to other provisions of this part, and also subject to the right of the state to make a legislation for social reform. Lordship, for this, if Lordship has page 4 of my written note, and I've reproduced that from my submission, so Lordship can just continue on this note. Lordship sees para 21. The reason why I say that consciously 26 was placed on a higher pedestal to 25, and 25 is made subject to 26 and not the other way around, is because under 25, an individual has a right under freedom of conscience to choose not to believe in God. An individual has a right under Article 25 to believe in God, but not to practice organized religion. An individual has a right in 25 to believe in an organized religion while declining to participate in certain practices of that organized religion.
That we understood.
And only at the last stage, having chosen not to exercise these rights, when an individual comes to an organized religion, an institutionalized religion, the individual is giving up all these rights and choosing to subserve his own right or her own right under Article 25 to practice religion to the collectives. And that is why the collective must have a higher right, because there is 3 levels of choice before you enter this space, and it is not, nobody is forcing you to practice organized religion.
Yes.
When you choose to, you have automatically surrendered some rights. Lordship, here I would like to take the example of a company. Now, Lordship, an individual has a right under Article 19(1)(a) to express an opinion. An opinion may be on a international issue, say of an ongoing war. I may take a position, I may voice an opinion in relation to Ukraine or Iran or Palestine or any conflict which is going on. But I can't, as a matter of right, demand that a company of which I am shareholder must, of necessity, reflect that opinion and say, boycott the goods produced in one of these aggressor countries, or not trade with an entity which is located in one of these countries. The corporation's right is not subservient to the right of the shareholder, because the corporation has certain levels of management, and that's the point that I'm trying to come to. That management is regulated by board resolutions, shareholder resolutions, special resolutions, and so the management will not be interfered with on the basis that the individual's right is.
Example will not come under this. We say the wrong example. Anyway, we appreciate what you are saying. Yes. We are not dealing with the company, we are dealing with the rights of the individuals. Yes.
Lordship,
yes.
Therefore, I'm saying that the collective, and I'm making that analogy to cooperative societies or and Mr. Rohde took the example of a club, that eventually the right on what you can and cannot do in that club will belong to the collective, and therefore the collective's right have consciously been placed above the right of the individual. That's my submission. Lordship, and therefore in this prescription, when we come to 26B, and 25.2, since in this formulation, the right of the collective to indoor management is what in my submission is covered in 26B, and the right of the actual practice is covered in 25.2. What lies at the cusp of this outward manifestation of practice and indoor management is entry. Because if you're looking at this inside-outside perspective, then the point at which the inside and the outside meet, which is the entry to a religious place, and that's why the question of entry is not simply only in 25 or only in 26. And the constitution makers have chosen consciously to keep a certain aspect of entry, which is a policy prescription or a constitutional imperative in Article 17, has been built into 25.2 and only to that extent. For the reason that, yes, like Devaru itself says that right to regulate entry is part of management. However, as insofar as entry of the oppressed classes into places of worship and the imperative of Article 17 is concerned, that read with 25, the second part of 25 subclause 2B will be a caveat or a takeaway from the right to religion itself. But however, any other form of entry, like I said, in this cusp of indoor versus outward manifestation, all other forms of entry will be in 26, because a religious institution will in other modes and manners have a right to decide who can and cannot enter the institution. So when the learned solicitor took an example that we all go to Hazrat Nizamuddin Dargah, that is true, but that is a right that the management chooses to exercise of entry by allowing entry of persons who are outside, who are non-adherents to the denomination. So that doesn't take away from the right, but it is an exercise of that right to prescribe.
Devaru says so, not difficult.
Lordship, please.
Devaru says so.
Lordship, please. I'm grateful, Lordship. Lordship, now on the question of denomination, the question that my Lord Justice Amanullah asked, and I said I'll come back to it. Lordship, in my reading, if we look at, and the Constituent Assembly debates at no point suggest otherwise, if we read at Article 26 to see, is there or is there not a denominational right in relation to this place of worship? It will lead to the absurd consequence that what we see as parts of right of management, for instance, ours, that the place of worship remains open. In what form or manner you can come, like Mr. Rodgi gave the example of shirtless or without shoes. A non-denominational institution will have no right of management. Because we are saying that right of management rests solely in a denomination. So where there is no denomination, there is no right of management, is a necessary sequitur. So, Lordship, my submission is that the correct inquiry in Article 26 is not, is there a denominational right in this place of worship or not? The correct inquiry is, who is the right holder for purposes of this particular institution or place of worship? Because in every instance of every religious institution and every place of worship, there will be a right holder of Article 26. And that's why it says, or section thereof, that in a sense, a non-denominational mosque is not a mosque which has no Article 26 right. It's just that it is say a section of the larger Sunni faith or a section of the larger Shia faith. So there will always be a denomination or a section of a denomination. The only inquiry will be, who is the right holder? It could be that the local masjid committee, which is organized by the neighborhood which uses that mosque. They will still be a right holder, and there will still be a right, because otherwise there will be no right of management in this masjid. It must be open at all hours. Anyone must be able to walk in and do whatever they please, because there is no right of management which is given by the Constitution. So therefore, the correct inquiry even is not, is this denominational or not? But the correct inquiry is to find the right holder, and in every single case, I submit with the greatest of respect, there will be a right holder.
If I've understood you correctly, you mean to say that the basic focus should be that the right is to manage. Now, everything, there is a modality to everything. There cannot be anarchy. Suppose there is a dargah or a temple. There will be elements associated with its entry, with the modality, how you worship, the sequence. Now, somebody has to do that.
I'm good.
There's nobody, I walk in, I do whatever, and I come back, all the gates are left open 24 hours. So who is that body who manages? And then that will come into the protection, because it has to be regulated. Per se entry cannot be banned, There cannot be discrimination on the broader constitutional parameters. But then for every institution, there has to be some norm. Now, who sets the norms? It cannot be that I decide my norm, you decide your norm, every individual decides their norm. There has to be a body, and that body has been given the protection to decide.
I'm grateful, Lordship. Lordship, therefore, there will be no place of worship which is devoid of the right of under Article 26, because otherwise, if it's just an Article 25 right, then situations will arise saying a dargah is a place of worship. You may have a right to go there and offer namaz, but I have a right to go there and do arti and bhajan. So, Lordship, therefore, just a 25 right becomes competing rights. You exercise yours, I exercise mine. Nobody has a right to manage. Therefore, every place of worship will have a right of the community that manages that place of worship, which will be the right holder. So the only judicial inquiry is who is the right holder under Article 26, not is there a right under Article 26. That question itself, with greatest of respect, Lordship, has been a misplaced question, which has been raised and therefore answered in some judgments. The only question and only inquiry is who is the right holder for purpose of 26, and that right will always exist. Lordship, because otherwise the anomaly that my Lord Justice Amanullah points out will arise where, say, a Daudi Bora place of worship, because they are a denomination, will have certain rights. A Khoja place of worship, because they are a certain denomination, will have certain rights. But a masjid, say, formed by the residents of a residential society or a neighborhood, which is open to all sections of Muslims, will have no right of management. And therefore, anybody can enter, like I said, and demand any right. So, Lordship, that right that I can't walk into a masjid and demand that I give the azan, irrespective of whether it is a denominational temple or not. And nobody can walk into a masjid and ring bells and conduct bhajan, irrespective of whether it is a denominational mosque or not, is a concomitant of Article 26, and the right holder will just be the local community. So the only inquiry is, what is that community? Is it the housing society? Is it... and so, Lordship, though it is a religious denomination because it is a religious place of worship. So the Muslims in place A, who are operating through a masjid committee, because a lot of the Lordship sees litigation around protection of mosques comes through masjid committees, which are largely informal bodies formed of namazis who are regular in that masjid, and they elect from amongst themselves on the Muslim principle of election or shura, the persons who are to represent. That will be the right holder. So that religious group will be the denomination or section thereof, which is in question for Article 26, is my humble submission. Now, Lordship, on the question of constitutional morality.
What else left? 40 minutes.
Lordship, I'll wrap up with just two remaining submissions. Lordship, on constitutional morality, Lordship, my submission is, a lot has been said on how morality is a new concept. Lordship, I'm just saying that morality has to be a legislative prescription. For the reason that there is a body of representatives which is elected to Parliament, and they speak for the people that this is today's idea of morality. That morality is the morality which is for using law, social reform, and read with morality can regulate religion. But my lords will have to determine that morality is not majoritarian morality. Because, Lordship, if we look at morality in Islam, alcohol is immoral and pernicious. But
morality, where is the question of majority?
Lordship, I'm just coming to that. So, Lordship, in Islam, alcohol is pernicious and immoral. But in a church, for the baptized, the blood of Christ is wine. So, Lordship, but if you allow one larger collective to determine what is morality, it will always have a majoritarian element.
Public morality, we understand that, no problem.
Lordship, and so when my lords sit in judicial review of constitution, a legislative prescription for morality, what comes out is constitutional morality, because Lordship makes sure that morality is not outside the bounds, the constitutionally permitted bounds, and it is not majoritarian. It is keeping in view the rights of the minority, and that when Lordships allow or disallow, and what remains of that Lordship. So in that sense, in constitutional morality here they are concentric circles. It is a subset of morality. So morality as necessarily in the first instance determined by the legislature, as examined on judicial review by my lords. What emerges then is constitutional morality, is my submission of, because constitutional morality has a different view in every context, is what my lords have held. And in this context, my lord, in my humble submission, this is the morality, because again, the principle of nocita esoci, if public order, health, and morality are treated separately, my lords always defer to the opinion of experts, and the legislature and the executive is the expert on this matter, on matters of public order and matters of health. My lords won't in the first instance say, in our opinion, this is contrary to health. There will have to be a policy prescription around health or around public order. My lords, for instance, in the first instance, will say, in our view, this is contrary to public order.
It is a
First,
public sense of morality. Public sense of morality. That is the way, what
Lord-
the public feels about it.
correct, Lordship. So, Lordship, and therefore that will speak through our elected representatives in Parliament. And my lords will then examine on judicial review whether it is outside constitutional parameters. And that then is constitutional morality for this context, is my humble submission. Lordship, just the last point, Lordship, on the essential religious practices element that Mr. Shamshad was dealing with, I just want to take 2 minutes Lordship, no, Lordship, there's something to be said on that, Lordship, which is that the Quran is actually a minimalistic document. It has principles, it has parables, it has morals, and in some cases it has specifics. But as my Lord Justice Amanullah also pointed out, it doesn't even have how you pray, how many times you pray, what time you pray. So while the Quran is the skeleton, the prophetic practice in Islam is the flesh and blood of religion. Now, Lordship, Quran was not actually written down in the life of the Prophet. Once the Prophet had passed away and it had been a few years, it was memorized in his lifetime. But there came a time when 72 Hafizs or persons who had memorized the Quran passed away or were martyred in a battle. And suddenly that fear arose that the Quran might cease to be with our lifetime. And that is when it was actually written down. And a conscious choice was taken not to write down prophetic practice. So that at no point is there any confusion or difference of opinion on how prophetic practice is actually, whether it's in this book or that book. As a consequence of that decision not to reduce prophetic practice to writing, prophetic practice was reduced to writing about 100 to 150 years after the life of the Prophet. And therefore, a hadith narration takes the form of, I heard from so-and-so, that he heard from so-and-so, that he heard from so-and-so whose father told him. Now, on this account, there is a lot of difference of opinion on whether one particular narration is right or not, one particular book is right or not. All sects and denominations and distinction in Islam arise on account of different people ascribing authenticity to different texts. So when the question is asked as a monolith, is this an essential practice in Islam or not? That question is ill-founded. And Lordship, and the consequence of that is, for instance, in the hijab matter, the right of someone who believes that it is mandatory to wear a hijab was made subject to school discipline. Why? Because the High Court, when it understood that it is not an essential religious practice, the High Court judgment was on the basis this is not an essential religious practice, therefore not protected, has no protection under 25, therefore doesn't have to be on public health, doesn't have to be on morality, doesn't have to be on health, it can even be regulated on the grounds of school discipline. So like the example Mr. Shamshad gave was of military discipline, and the Justice Baki rightly pointed out that there's Article 33. And while there may be something to be read, because that case was around the interpretation of the rule to say that prohibited except when demanded by religion, is that only for Sikh officers or is it also for Muslim officers? And to that, the answer was given saying that it is not essential to Muslim officers and therefore that right is not available. So in that sense, that is also one of the victims in that sense, that right is of the essentiality test. But here, Lordship, the right to wear a hijab was made subject to school discipline. And that can't be the...
So, Pasha, that is not an issue before us. Essential practice, we understood the word essential. Everybody has explained that how.
And Lordship, therefore, it cannot be only essential practices, because if it is essential to that student to wear a hijab to school...
Mr. Pasha,
Lordship.
in a lighter way, you said that all this confusion is created by us. There's a beautiful couplet by Ghalib for believers, non-believers. कुछ नहीं था तो खुदा था, न कुछ होता तो खुदा होता, मेरे होने ने मुझको डुबाया, मैं न होता तो क्या होता. So all this is created by us.
That is true, Lordship. I'm extremely grateful, Lordship.
Ghalib. Thank you, Mr. Pasha.
Grateful, Lordship.
Mr. Sridhar.
May I please, Lordship? I'll be referring to volume 1.7, my lords. There are excerpts of books I've given. It's handed over.
Are you also supporting review petitioners?
Yes, my lord. Sorry.
My lord, yes, just 15 minutes, my lord. We represent a group for the sacred groves. For sacred groves, and just a few perspectives I want to point out.
No, we want to identify you this side or that side.
This side, this
All
side.
right, yes, Sridhar.
Lordship,
I was not sitting on the fence.
Also request to.
All right, yes, Sridhar.
Lordships, I have handed over an argument note today, my lords. I've recrafted the original submissions because much has been said.
Yes, you can start.
Yes, I'll straight away take lordships to this note, my lords.
Huh.
And then lordships would kindly see my volume 1.17, the excerpts, which is part of the compilation the nodal councils have given. I've footnoted most of the things, my lords. Lordships would kindly see. My argument, my lords, is broadly premised on the need for freedoms guaranteed under Part 3. The constitutional framers had acknowledged the historic challenges that this nation has faced, and the Constitution Assembly debates and also the judgments of this Honorable Court have extenso referred to the historical challenges of slavery, etc., etc. I've referred to them in my Part 1. Fundamental rights in Part 3 of the Constitution, Para 1, my lords. The heading I've given. Fundamental rights in Part 3 of the Constitution need to be understood having regard to the history of the nation. Here I've accepted, my lords, from Lordship's publication, The Courts of India, Past to Present. I'll just read. The 5,000 years of India's history, from the very dawn of that history, which might be considered almost the dawn of human history till today. So therefore, Lordships, when we are looking at the fundamental rights chapter 25 to 28 of religion, conscience, etc., Lordships would bear in mind the history of this land as judicially acknowledged. Now, Lordships, the second aspect is, what were the challenges that we faced in these last 1,000 years? As Justice Kuldeep Singh has said, this country remained under shackles of slavery for over 1,000 years. In his opinion, Indra Sani, I've referred to in Para 4. So what were the challenges, my lords? I've actually extracted that by way of a history of religious persecution from 997 AD onwards. In a table, that's an annexure A. Lordships, that is only to give a background as to how the framers of the Constitution had the history of lived experience of the people of this land. Lordship, the preamble says, we the people. So therefore, we the people have reserved certain rights when the Constitution comes into force, and we have distributed those rights through the three organs of the state. My submission, Lordships, would be in this backdrop that the sovereign has parted certain powers and reserved certain powers. Now, Lordships are being called upon to interpret the powers which have been reserved by the sovereign in Part 3, especially 25 to 28. Lordships would kindly see that here in the Indian pantheon, my lords, there was no concept of religion. In fact, the expression Hindu is a appellation given to us by foreigners. Neither we call ourselves Hindu nor do we call ourselves India. We call ourselves as the followers of Dharma. And the Dharma has been the eternal Dharma, which does not have any concept of infidelity, blasphemy, or any such others. For us, there are multiple philosophies. Those philosophies are in practice of the people, each to his own conscience. Some may be satiated through certain philosophies. Some may be satiated through a combination of rituals and philosophies. So therefore, Lordship is now being called upon to test these diversity. Because if India is a geographical appellation, and then Hindu is referred to with reference to the geographical entity of the subcontinent, now what are we defining Hindus as? Because the Constitution has chosen not to define Hinduism. It only uses 25(2)(b) explanation to include, for the purpose of 25(2)(b), Sikhs, Buddhists, and Jainas. But it again doesn't define Hindus as to who are Hindus. It's only an inclusive definition, which invariably would include everyone who inhabits in this land, but of course subject to certain broader understanding. In this context, I have placed on record, my lords, in my excerpt from book, Swami Vivekananda, Aurobindo, and also Paramacharya Vakanchi, who have actually explained this concept and the distinction from Will Durant's Story of Civilization and Al-Biruni also. See, the diversity of practices that Al-Biruni notices, my lords, in 11th century AD, he describes those practices in detail. Now, if you talk about this, if you are a Dharma-adhering society, what are we looking at? We are looking at Purusharthas. Dharma, Artha, Kama, Moksha. Now, for my Dharma, I would pursue my philosophical or spiritual paths. For Artha and Kama, I may believe in certain rituals and practices and prayaschitas or yajnas. Those practices are the rituals through which I would achieve certain end goals, to pass an exam to be at the lowest, or to become probably a very high constitutional officer at the highest. There are rituals, there are prescriptions, and there are also prayaschitas for actually participating in a process of what we call as condoning or probably seeking condonation for the sins we would have committed knowingly or unknowingly. So there are certain rituals. Now, there are multiple aspects of life which are brahmacharya, vanaprastha, grihastha, and sannyasa. Now, if you look at this larger plan of life, so the right that I'm canvassing is Article 21 with personal liberty to choose the path I believe in with all its variations. probably I'm in a missionary school. I actually go to a church. Sometimes I go to other places of worship also. I revere because for me as an Advaitan practice, there is no other for me. So I can see and connect through any other modes of worship. Now, in this background, Lordships would kindly see Venkatramana Devaru's fact, page 4, para 10, my lords. Much has been said. I'm not going to go into the nuances of the law. The reality of history of this land, my lords. Venkatramana Devaru's quote, the extract lordships would see in bold. The Gauda Saraswat Brahmins' journey in this country, my lords. In the distant past was Kashmir. So they've migrated from Kashmir at a point of time. They go to Mithila, Bihar. Then they settle down in Goa. Then they suffer persecution in the hands of the Portuguese. And thereafter they go to Bhatkal. They have their own language. They have their own deities. They identify as a group. Now what happened when the question was whether you are a denomination in an understanding minus the historical background, you fail the test. My later submission will be, my lords, if it is a fundamental right which the sovereign has reserved to itself, where is the question of qualifying any test? I don't need to qualify in any test which is not part of the constitutional document and text itself. Where is the my right and to assert to establish a jurisdictional fact is a respectful submission. I'm so sorry. Sorry. Lordship, now that I've made this point, well, I'll move to the next point, conscious of the Kala Dharma, my lords. Lordships have already spent enough time. Lordships will now kindly see what is the character of a nation. Swami Vivekananda has this to say. As far as the French are concerned, the political independence. Lordships kindly come to page 5, para 13. The French, the political independence seems to be the character. Quoting Swami Vivekananda, the excerpts are there in my volume 1.7, Lordships. For the British, it's equity, equal partition of privileges. Now, as far as India, what is the character of this nation, my lords? The Hindu says that the political and social independence are well and good, but the real thing is spiritual independence, mukti. This is our national purpose, whether you take the Vaidika, the Jaina or the Bauddha, the Advaita, the Vashishta Advaita or the Dvaita, they are all of one mind. So therefore, my lords, the diversity of worship is a very organic thing for this nation's character. So therefore, as I said, there is no infidel, there is no kafir, there is no blasphemy, there is no inquisition at all that we can relate to this land. These challenges came about when there were invasions, there were cultural exigencies. Now, why not in my list of dates, the Pennexure A, I have referred to the instances expressly, including the Borden chair in Oxford, which actually has a Sanskrit chair. Lordships, Monier Williams, English to Sanskrit Dictionary, Lordships would see, I have 2 volumes of them. The preface is edited. I had to search for the original preface. There they categorically state, and I've enclosed that preface, my lords. Lordships would kindly mark just page 28 of this compilation, since I'm on this point. Page 28 of my note, my lords.
Yes.
Lordships would see the para. In explanation, I must draw attention towards the lower part. Lordships is marked. In explanation, I must draw attention to the fact that I'm only the second document of the Borden chair and that its founder, Colonel Borden, stated most explicitly in his will, dated 15th August 1811. The special object of this munificent bequest was to promote the translation of the scriptures into Sanskrit, so as to enable his countrymen to proceed in the conversion of the natives of India to the Christian religion. So this was the benevolent object, my lords. In his faith, he believes this is benevolent. Lordships would kindly have a page over.
Library named after him, you know.
Yes, my lords. Yes, my lords. Knowing history, lordships are recorded in Property Owners Association is very important for this very purpose. Otherwise, we believe what they say. Lordships, page 29. The second line on page 29, my lords. My very first public lecture. delivered after my election in 1860 was on the study of Sanskrit in relation to missionary work in India. So therefore, Monier Williams, when we all rely upon, and I've always relieved, in fact, the other day I was using a Benjamin Walker's dictionary. My learned senior colleague, Mr. Gopal Subramaniam, said that that may not be accurate now. Because as we may know, Mr. Gopal Subramaniam, my lord, Benjamin Walker's Hindu Encyclopedia. Because trying to know my religion, my device is only an Englishman's dictionary or Englishman's publications. Now, therefore, Lordships will, while interpreting 26, now Lordships will kindly come to my next point. These are the constitutional interpretation, my lord. Lordships, kindly see para 15 at page 7. My proposition is this, my lords. Religion broadly, as it is understood, not from a Sanatani perspective, but from a dogmatic perspective, which the West always understood. Because we are in a common law system where the constitution is to be interpreted with certain limitations of language. The religion, as I see, has three aspects, my lords. The first one is the spiritual and the philosophical aspect, where I don't practice any rituals, I don't do any discipline, I don't even take bath, but I'm in contemplative mode. That is permissible. And that has very minimal external interference or manifestation. And that's exactly how our Vedas have been preserved. Through memory within the families, through the religious persecution and migration stories. The second part is, my lords, the practice of the rituals. Starting from all the karmas that is being performed right from the Garbhadharana onwards till the passing away and the Pitru Rina, all the other obsequies which are to be followed. These are all rituals. The third part is the political part, my lords. As I've pointed out, the political part comes from an influence of the French Revolution, which had an impact in interpreting our constitution. That's where our secularism comes in, and then that's where the interference into the religious aspects, and also state policy of religion also was that part, my lords. Now, in this background, lordships would kindly come to page 8. I've made this point, my lords. Jurisdictional fact need not be assumed. I'm sorry, my lords. The jurisdictional fact of me qualifying to be entitled to a right, with greatest respect, my lords, is a misnomer. On the contrary, if my right has to be curtailed, there should be an authority which is expressly provided in the Constitution, is a respectful submission, my lords. Now I move to the next point. In this para 25 lordships, I have quoted para 38 of Justice Ramasubramanian's Kaushal Kishore opening statement, where he said, courts cannot restrict the fundamental rights. The legislature and executive, they do it. I ask myself this question, my lords. If the legislature passes a law, I come to the court to challenge it. The executive dumps something, curtails my liberty, I come to this court. But if in a 32 petition, my rights are curtailed, where do I go as a citizen? That is something lordships will have to bear in mind while interpreting, my lords. It is for the lordships' wisdom to take a call on that. The next point that I'm making is, my lords, by interpreting limitations of 25(2)(b) into 26, are we actually creating an interpretative causes omissus in order to fill a gap which, to my respectful submission, does not exist in the plain reading of the Constitution for these 75 years? Nobody found that there was anything lacking in the language of the Constitution to interpret it. It is in the interpretative process, if something is to be shifted from 25(2)(b) into 26, with greatest respect, my lords, that is not within the domain of an interpretative process of causes omissus, which this honorable court has repeatedly held. For that, lordship, para 29, State of Karnataka, Chief Justice Bake's reference I've given, my lords. And thereafter, lordship would see Justice Ramaswamy also on similar principle of causes omissus. Then lordship would come to para 33, the heading I'll read, my lords. Freedom of every religious denomination or any section thereof inherently recognizes the choice of persons with whom they associate under Article 26. It's a very inherent right, my lords. Lordships don't even now issue a decree of conjugal rights under Section 9 of Hindu Marriage Act anymore with the changed society. Now, the right to associate is an inherent right which says the choice of people with whom I choose to associate in my chamber, in my house, in my neighborhood, or wherever I choose to in my public life. Similarly, in my spiritual or religious life, my lord, we experience energies. Some people you get a positive energy, some people you get a negative energy. I may choose to be with people with whom my spiritual practices align with. So therefore, lordships may have to consider this aspect also while interpreting Article 26, with reference to the right of the denomination or any section thereof. Lordships, on this point, the expression denomination or the Hindi version Sampradaya have their own independent existence. In the constitution, they have been qualified with religious denomination or Dharmic Sampradaya. So therefore, they have a meaning and contours outside the scope of religion. A Lions Club or a Rotary Club, some other forms of denominations are there which they practice some rituals. They may technically fit the test of Devaru, but they may not be religious.
Understood, Mr. Kotal?
Lordship. Now the last point, my lords, what Dr. Dhawan has said. I've quoted the judgments, Lordships, on 19(1)(c), Damayanti's Constitution Bench judgment. Lordships have categorically held that under 19(1)(c), a secular association also, the legislation cannot open up the membership to anyone and everyone. Lordships, here in an interpretative process, Lordships will have to bear in mind the constraints. That has been explained in Zoroastrian society, my lords, where this aspect has been dealt with extenso. Lordships, page 15, last paragraph of Zoroastrian. I just want to place that, my lords. And then the last point that I have. Although, page 15, my lords, the extract of page 662. Although theoretically it was permissible to evolve a new head of public policy in exceptional circumstances, such a course would be inadvisable in the interest of stability of society. Lordships would bear this in mind. And the last point, my lords, PALs or derivative PALs that Dr. Dhawan has said. Lordship, here I quoted para 40, the advice of Sri Rama in Valmiki Ramayana to Bharata, and adopt it as my submission, my lords. I'll place it. I hope this is a conversation in the Kachita Parva of Ayodhya Kanda of Valmiki Ramayana. The English version from the Gita Press I've extracted, my lords. I hope you do not patronize atheistic. Oh dear brother, for ignorant and conceited as they are skilled only in perverting the mind and thereby diverting people from the righteous path. Banking solely on their logical acumen, these men of perverted intellect preach nonsense even in the presence of foremost of books of Dharma. For a religious person, the dharmic values that my rituals or my religious texts prescribe me are paramount. Someone who is an atheist or a non-believer will have to be discarded even by this honorable court when you are testing my faith, my rights is my respectful submission. I'm so very grateful, my lords.
Thank you, Mr. Sridhar. Madam Balu,
15 minutes at the very most, and if I make a repetitive point, please stop me. I won't. My lords, I appear in IA number 101671 of 2026. I'm handing over a set of written submissions. I'm not going to trouble you at this stage. Only one aspect I will refer to them. Now, my lords, we support the rights of worshippers of what are known as sacred groves. I'm going to only spend 2 minutes indicating to your lordships what this means, only for the purpose of being able to, my lords, your lordships to be able to appreciate the phenomenal diversity and magnitude of what your lordships are actually dealing with in practical terms. Now, my lords, this belief system, and we are concerned with sacred groves from Western Rajasthan, essentially. These are known as Devbans or Orans. Orans, which stretch over, my lords, vast stretches of, my lords, largely forest land. And where, my lords, the belief system is that, and this is as old as the ages, it's from the Rig Vedic, and we have traced all that in our IA, etc. I'm not troubling you, but just to indicate that the manifestation of the divine goddess is in the forest itself. So there is a temple, a Kul Devi, etc. But the manifestation of divinity is essentially in the forest. So very close connection with the ecological aspect. And there are many forms of nature worship that your lordships know about. But in this particular form of belief, there is absolute non-violence, ahimsa, and customary abstinence, which is maintained qua these forests. And therefore, my lords, if a worshipper damages or hurts the forest in any manner, there is a penance, etc., customary. Now, what is important is also that these orans or devans are unique from one another. So you may have a certain stretch. So it's a common belief system arising from Rig Veda, but each oran is a separate, unique one because it is consecrated to a different Kul Devi. They have their own folklore, their own customs. So one is distinct from the other. Why, my lords, this is important? Because this is about village folk. It's not very organized. They don't have that sophisticated, my lords, organizational skills. And therefore, my lords, they fall between two stools, between the essential religious practices and denomination. So this is what, my lords, I want to, therefore, in the tracing the relationship between 25 and 26, I want to emphasize, my lords, the and a better appreciation, perhaps, if I may say so, of the expression denomination. Because in our respectful submission, we are entitled to rights under 25 that nobody can dispute. But even to enjoy 25, we need 26. And I will establish that. Now, my lords, there's no dispute. 25 and 26 are in many ways distinct rights. One is individual, as we understand it. The other is institutional, right? But the relationship between the two is one of, my lords, it's symbiotic and reciprocal. In that, my lords, what would the institution be? What would the institutional right be without the followers? It's an empty, hollow right. It exists in order to sustain, to educate, to further the right to propagate, to believe, the freedom of conscience of the individual believer. So, my lords, in our respectful submission, because 26 is essentially there to subserve the rights of individual believers under 25, and therefore 26, even though it may have its own status, it has its own identity, but it is ultimately, it's a means to an end. It's a means to an end to ensure that the individual under 25 is fully facilitated in being able to practice, propagate, and the freedom of conscience. And I'll just come to that in a moment. But, my lords, when we look, sorry.
Just interrupting you. What do you mean they have the persons who represent? They believe in what? I couldn't understand.
Yes. So, my lord, these are called sacred groves, as in, my lords, clumps.
What will be the areas and all? What would be
My lords, these are, for instance, in Western Rajasthan in particular, and there are sacred groves across the country.
Forest.
There are forests.
Then, no. Madam, then probably we are entering into some dangerous territory. By that logic, the tribal would say, entire forest is mine. I have been worshipping this. There has to be some limitation. You can't be so vague that this entire area, I believe in a...
That limitation is in 25.
Some circumspection.
Yes. So that limitation will be in 25 and 26. Of course, we are, my lords, ecologically also, it's been recognized from a preservation of forest and ecology point of view. But today we are on 25 and 26. And therefore, I am entitled to the rights, whatever...
The foundational facts is... We can't abstractly say.
I'm not asking your lordships, and I cannot ask your lordships to determine my rights over here, but I am asking your lordships to take this. This is judicially determined also insofar as the rights of believers in sacred groves are concerned. We have, for instance, Niyamgiri Hills. I'm not representing them, but we have the Niyam Raja from Niyamgiri Hills. There are water temples in Uttarakhand. There are all sorts of form of nature where nature is revered, and this is really important for our current issues also on ecology and climate change. So, my lord, we will have restrictions, but only governed under 20.
Worship.
Yes.
The form of worship, it can be a religious practice. Nobody is denouncing it.
Yes.
Your right, your conscience, nobody is denouncing it.
Right.
So there is nothing that you see that you can seek as such.
So
it's already protected under 25(1).
My lords, there are inroads into it. There are inroads through, my lords. There will be vested interests, there will be builders, there will be all sorts of things which come into the picture. But let me not get into too many details, but there are inroads, which is why we are here. Now, my lords, I wanted to explain on the principle, once we look at 26, and this is true of anybody, my lords, 26 is a means to an end. Ultimately, it cannot exist by itself. There's no institution without believers, or at least potential believers. Right. One, if that is so, and secondly, if all persons are equally entitled to the freedom of conscience, right to practice, propagate, preach, etc., and propagate, then, my lords, seeing these two provisions together, then what does it mean? All persons are equally in this context. It means that if you and I belong to different religious affiliations, we are all entitled to the support of an institutional right. And let me explain this. So it may be that I belong to a group which does not fall into the, my lord, what I would describe only as tick the boxes definition of denomination, common faith, common name, common organization. And I'm emphasizing organization. What if my group doesn't belong, but my neighbor's group does belong? Then how will it inform our respective right to freely, my lord, even conscience, right to practice, propagate, etc. How will it work out? Now, for instance, my lords, even when we talk of the most personal and private of rights amongst the range of rights that are afforded under 25, your lordships will see right to the freedom of conscience is the most personal and private. Nonetheless, even this right will not be in a vacuum, because as a believer who wants to practice that freedom of conscience, even in the privacy of my home, I may require, my lords, for instance, religious texts to read. I may require access to libraries. I may choose not to, but I may require the support of an institutional apparatus, of an organizational structure. I may want to go to a monastery and learn from the experts over there, etc. So in that regard, even for the freedom of conscience, which is the most private and personal of the range of rights afforded under 25, I will be nourished, my right to freedom of religion will be nourished and supported and sustained by the rights that I get from the institutional. An institution may not be a building with, it can be anything, the collective. I may have, my lords, I may require mentorship. Even that is an institutional right. Guidance, whatever it be. So each of these rights, and particularly, my lord, propagate, which is the most, my lords, outward manifestation perhaps of the freedom of religion. For that, I will most likely require the assistance and support of the institution. So if we see these together, please now see the definition of denominational, how discriminatory it would be if I don't fit, my group does not fit into that tick the boxes denomination, whereas somebody else's does. So that will, my lords, denude and impoverish my right to religion under 25. So therefore, my lords, and I am supported in this, and when we read Shirur Mat and the definition of denomination in Shirur Mat, my lords, I don't know why it is, but the court chose a very restrictive definition which requires all of this. What happens, my lords? Emphasis on organization. My lords, we, for instance, would be village folk, rustic. We don't, for organization and to fulfill that requirement as stands today of denomination, you require resources, you require organizational skills, you require a whole, my lord, a whole apparatus you require.
We understand your argument. Your argument is there is nothing different between 25 and 26. 26 is meant to give effect to 25.
Yes.
What is important is a conscious and common belief. So there's not much of a difference between persons and the institution. Institutions are meant to give effect to the right to practice, profess, and then propagate.
It is a meaningless right.
It's an end to achieve the mean. So therefore, it is to be understood that way. Therefore, no question of reading it together, or you can say that it is harmonious construction. All those things are not required, because once follows are there, because if 26 stands alone, say like they're contending, it's a standalone article, then right into 25 will go.
Correct.
Say
Who
now,
does it exist for? 26 is
nothing,
not right.
nothing but a collection of the common believers
Yes.
who create the institution only to propagate and profess.
Right.
That's what you're saying, Javier.
So my lord, I maintain,
Therefore, the definition of religious denomination will have to be given a wider import.
much wider, and my lord,
What you're saying, it should be given a wider import, number one. Court should not get into it, because it comes under 25. See, it is protected under 25. So it is actually 26. You have to, it is only for management and administration. Otherwise, the rights are also there in 25.
my lord, I would just refine it to this extent. I maintain that 25 and 26 are qualitatively and in content distinct rights. 25 is the right of the individual, all persons equally, but not an institution. The 26 right is of the institution. In order for me to be able to, and institution in the sense, it may be organized religion, it may be not so organized religion, but it is a collective and institution, etc. Now, to enjoy 25, which is the individual's right, I need 26, and 26 will not exist but for the believers in 25. That is my short answer on that.
This by Surur Mat, it says, there's one passage in Surur Mat, it says, whatever happens in temple, church, or mosques, we are not concerned. What is relevant is the right ensured into 25.
Yes.
So long as that is there,
Yes,
now these other things will, what they mean is the religious, their denomination also.
correct.
The idea is to protect the right in a 25. If you,
Absolutely.
with that mind, if you read 26,
Absolutely.
there is no need to read part 3 into it, whether it have an independent right, conscience, all those things are not right. You
Yes, and
understood?
I'm also saying, my lords, that ultimately, in order to be able to, my lords, you need organizational skills. It can't be all persons equally means we are people who belong to
That's right,
different.
you understand? Practice and profess.
Yes.
And then propagate.
And it would impoverish my right under 25 if you are not going to treat me as a denomination.
Cannot be also read rigidly. Cannot be so
Denomination,
rigid.
yes.
Yes.
And I have,
These
my lords,
people
in
who
this regard.
follow a particular practice, they've come to that, a rigid organization is not necessary. also.
Right.
They
My
all
lords, what
follow
I
a
have,
practice.
I have put in my written submissions, my lords, I have
See, in other words, what will be put it simply?
meanings.
The denomination, religious denomination, it is nothing but a creation of the collective rights of a common believers.
Absolutely.
Yes.
Which your lord, what your lord
Therefore,
say.
it derives its existence, functions, performance through the collective this of the
Absolutely.
common believer.
Absolutely.
In other words, a denomination cannot go against the common believers. It will only give effect to the common believers.
Correct.
That's correct.
And my lords, if your lordships require any meanings of denomination, they are set out from Black's Law Dictionary to Webster's to all of them give a much, much wider. And that's in my written submission. My lord, the other point that I did want to make here is ultimately what the court, my lord, ultimately your lords are assisted by the bar. But what has happened is that instead of treating the right as fundamental, it is the restrictions which have been treated as fundamental, because when we talk, my lords, if there are two interpretations available, say of denomination, what is a denomination? If there are two interpretations available, the court must adopt the meaning which furthers the fundamental right, because the right is the one that is fundamental, rather than to constrict it and box it into this, tick the boxes. Are you an organization? Are you this? Are you that?
You've already argued.
Yes.
You've
So,
argued.
my lords, therefore, that is one aspect. Now, my lord, the other aspect, please do consider, because what will happen otherwise is this is a recipe for, my lords, competition to gain denominational status. It will lead to polarization. It will lead to a sort of survival of the fittest. He who has the resources, he who has the organizational skills and the wherewithal will be able to get the recognition, and therefore their rights will be, in a sense, higher than mine. So that is, my lords, and that polarization, my lords, violates the fraternity principle. So please do bear that in
If there
mind.
is polarization, the state will step in under Article 25 2B. That is reform.
My lords, reform,
So,
yes,
they
yes.
have to- that is why in Venkatramana Devaru they said, ultimately you see which is what is the right here, what is the right there. If as you are saying there is polarization, then the state can step in under 25 2B with regard to social reform.
If social reform is required, if there's a social evil to be addressed,
Necessarily.
my lord, it can't be just an improvement. That's my submission.
If social reform is required, you said polarization.
My lord, polarization is in the context of this competition. You and I am a denomination. You are not a denomination. Let's get the status.
It doesn't apply. That is not the subject matter actually.
My lords, we are.
See, we are
Yes.
saying that some denomination is superior or some other denomination is inferior. That is not the.
No, not at all. Question is, am I a denomination or not? That's the question. Do I get the right under 26 or not? That's the question. And if that is the question, then, my lords, it cannot be that because you tick the boxes, you get the status.
See, what it means is some religious practice is followed by a religious denomination. Their autonomy to practice that religious practice
Yes.
is protected under 26B. The state or the court cannot say, no, this is not a religious practice. You don't have a protection.
Correct.
That autonomy is protected. That is what 26B says.
That's correct. But yes.
In the guise of saying I have this autonomy to protect a religious practice, I will do something which is affecting society as such,
No.
then 25(2)(b state will step in.
Right.
That is how you have to harmonize. That's
My lords,
what
I would
Venkatramana Dev said.
respectfully submit that today we are only, as far as I am concerned, my submission is only on who is constituting that denomination and who is entitled to the autonomy under 26.
You understood that part.
That is the absolute. My lords, therefore I just submit there are a few more submissions.
Mr. Devan,
And-
we are probably not here to decide which is a denomination or not.
We'll see what.
But in an interpretation of 26,
These are not the procedure.
not a particular, but the principles, your
It
lordships.
can never be a final. Case to case.
Controversy in this case.
When you have a real grievance, you come case to case, it will be.
Well, that of
Exception,
course, but your
exception,
lordships
state box,
will interpret as to what is a denomination.
Well,
I'm grateful. my lord.
We sum up your argument on the 26, we say, if the essence of 25 is to be seen in 26, do not get into this, leave it to us, is what you are saying.
Yes.
My lords, I will take 10 minutes, my lords.
Just 2 minutes, Manoj. Take.
Wait, don't yourself start. I will have to decide who will come first.
Yes, my lord.
Small argument note, Milords. My submissions are there on record,
Please
Milords.
don't go to your notes now. Nobody will refer to notes. You straight raise your point, we will note down.
Yes, Milords.
Otherwise, each one.
Milords.
Yes.
Yes, Milords. Milords, I am on the historical part of the temple, Milords. Milords, here what has happened is there is a Tripati Danam which has been executed by the king, Milords, in 1750.
State
Now,
company
Milords,
point.
that's on the sovereignty of the kingdom, Milords, and which then goes on to the sovereignty of the state and then the sovereignty of the deity, Milords. Therefore, Milords, there are documents which have been executed, starting from the Tripati Dhanam, then the proclamation of 1936. Now, Milords, by the proclamation of 1936, Milords, various persons under the SC/ST category, like Milords, the applicant here, Milords, she is from this community and she has been given the rights to enter the temple. Now, Milords, from there on, Milords, till Milords, the objective resolution, Milords, which has also been brought out in the Keshavananda judgment, Milords, all these provide that it is the sovereignty of the deity which has to be respected. From there, Milords, to the preamble and 26(2), Milords. Therefore, what we are saying is, Milords, 26 really protects the rights of all the religious denominations and the sects, Milords. All those rights need to be given their equal protection, Milords, and that balance has to be brought out. Milords, just 2 lines from the judgments, Milords, where it has not been relied, not quoted, Milords. TMA Pai, Milords, has brought out, Milords, this fine distinction, Milords. I have quoted that, Milords, which is at page 2198 of the compilation, Milords. In TMA Pai, Milords.
Just read.
Yes,
Which volume?
I'm so obliged. TMA Pai, Milords. Article 25 gives to all persons the freedom of conscience and the right to freely profess, practice, propagate religion. That right, however, is not absolute. The opening words of 25(1) make the right subject to public order, morality, health, and also to the other parts of Part 3 of the Constitution. This would mean that the right given to a person under 25(1) can be curtailed or regulated if the exercise of that right would violate other provisions of Part 3 of the Constitution. Therefore, Milords, where 26, and therefore, Milords, between 25 and 26, if 25, Milords, is trying to violate upon 26, Milords, that can be curtailed is what the Honorable 11 judges of this Honorable Court have held. And, Milords, thereafter, Milords, one more para below that, Milords, the freedom to manage religious affairs is provided in 26. This article gives the right to every religious denomination or any section thereof to exercise the rights of, that it stipulates. However, this right has to be exercised in a manner that is in conformity with public order, morality, health. Clause A of the 26 gives a religious denomination that right to establish and maintain institution for religious and charitable purposes. There is no dispute that the establishment of an educational institution comes within the purview. Now, look at the next line. Therefore, while 25(1) grants the freedom of conscience and the right to profess, practice, and propagate religion, 26 can be said to be complementary to it and provides for every religious denomination or any section thereof to exercise the rights mentioned therein. Therefore, Milords, it has to be considered 26 as complementary to 25. 25 cannot supersede on 26 is my argument, Milords. And, Milords, thereafter, Milords, SP Mittal's judgment, Milords, I have quoted out 2 paras, Milords. SP Mittal has been read out, Milords, on the religion part and how it has to be considered. Mulods, in Maneka Gandhi, Mulods, just 3 lines of Maneka Gandhi, Mulods, on the proportionality principle that your lordships, Justice Bakchi was referring to. Mulods, Maneka Gandhi says, we do not think that this would be a correct way of interpreting the provisions of the Constitution conferring fundamental rights. The attempt of the court should be to expand the reach and ambit of the fundamental rights rather than attenuate their meaning and content by a process of judicial construction. Therefore, Mulods, my submission is that a construction should be made so as to give it an expansive meaning. Referring to Article 26, Milord, it has to be given its expansive meaning in a way, Milords, whereby all the religious denominations, all the sections are covered. Milords, in detail, what is a religious denomination, what is the section has already been explained, Milords. Milords, sovereignty of the place, Milords, we are also saying that the temple, Milords, is a sovereign place itself. The deity resides over there, and therefore it has its own unique feature, and therefore the importance to that place has to be given its due weightage. I know, Milords, your lordships are not going into each facts, but Milords, then Milords, when the questions of law are being considered, Milords, your lordships will have to determine where do we strike a balance, Milords, between 25 and 26, Milords. Throw 3 paras, Milords, which I have brought out in my written submission at page 11, Milords. Just 3 paras, Milords, very short 3 lines, Milords, between the interplay, Milords, in this background. I'm sorry, Milords.
Para numbers?
Yes, paras 25, 26, 27 of my this argument note.
All right.
The significance of Article 26 of the Constitution assumes great importance as a constitutional provision capable of serving as a beacon of light to the entire world by guaranteeing to every religious denomination or section thereof the right to manage his own affairs. In matters of religion, the Constitution of India provides a framework for peaceful coexistence amongst diverse traditions of worship. The applicant submits that 26 was conceived as a constitutional safeguard for the independent functioning of the religious traditions and the institution. The pious purpose underlying the provision is therefore to ensure that diverse modes of worship may coexist within a constitutional order founded upon fraternity, dignity, and unity. And therefore, Milords, I would say, Milords, this writ petition which has been filed, Milords, therefore your lordships will also have to lay down.
Don't try to be impatient. Otherwise, I will close the proceeding.
I'm sorry, Milords.
Mr. Upadhyay, 5 minutes.
Milords, Milords, only last point, Milords, that Milords, under 32, Milords, these rights should be curtailed, Milords. There is Article 363 also, which provides, Milords, where there are rights flowing before the Constitution, Milords. How do you determine that? And therefore, wherever those rights of the kingdom are being taken away, Milords, that will have to be appreciated under 363. I'm so obliged.
Thank you. Mr. Upadhyay, no reference.
Will not repeat even single sentence. So I humbly
We
request.
will, yes, you start your,
My lord,
you leave our homework to us. You complete yours.
my lord, this submission is in 3 parts, my lord. The first on the 7 questions of law, and the 7 frequently asked questions asked by your lordships, and my submission on the Sabrimala. Second part, my lord, is the relation between Article 25-26 and 29-30. The third part is, my lord, Dharma and religion. Lordship's motto is the Yato Dharmas Tato Jaya, not Yato Sampradayo Tata Jaya. High Court motto is the Satyameo Jayate. And your Lordship submission is the Yato Dharmas Tato Jaya, because Dharma is above the Satya. So I have dealt, my lord, in third part. My lord, just see my brief, my lord.
Please start.
Yes.
We are concentrating on you.
So as far as the, my lord, Article 25 and 26 is concerned, my lord.
Come the third part, that's better, no? Because that's a new point you are raising.
No, I will also, my lord, say, just see the constitutional oath of your lordships and constitutional oath of the ministers, union ministers, and the constitutional oath of the ministers. So lordships oath.
Whatever you want, you have asked for 10 minutes, we have granted you 5.
My lord, this is
Your
totally
chart-
new, my lord. Totally
Ask
new.
for 10 minutes you have asked.
Yes, my lord, definitely.
Please confine to that.
So lordship's oath is to uphold the constitution. Just see the Schedule 7. Oath of the legislature and executive is act according to the constitutions. Upholding the constitution have higher value than acting according to the constitution. Third, my lord, Bharat have been divided in last 2000 years in 25 pieces. That was not due to religious conflict between individuals. Bharat divided in 25 pieces in last 2000 years due to denomination conflicts. And in last 200 years, Bharat divided in 7 countries. Third, my lord, I have also considered that every action has a reaction. Similarly, every judgment has a ramification. Being an engineer, my lord, earlier I was an engineer. So I did the 5W analysis, the Wi-Fi analysis. What will happen if the lordships will accept my senior's argument? What will happen if not accept argument? What will the ramification? Whether in the next 25 years, we will become a united, integrated, scientifically developed country like China, Singapore, Japan, or in next 25 years, we will become countries like Pakistan, Afghanistan, and Bangladesh. So I have all the reasons, my lord. Let me see the under Article 25 and 26. Article 25 and 26 is the most restricted provision. None of the fundamental rights so restricted, my lord. Right to propagate religion has not been given in those 10 countries. From we adopted some parts. The 10 countries we have taken something from the South Africa, from Germany, etc. my lord. Even those countries have not given right to propagate not only the denomination, even to the individuals, even till date. So Article 25, subject to public order, health and morality, subject to 27, subject to 28, expressly subject to other parts of the provision. Article 26, subject to public order, health and morality, impliedly subject to other provisions, and expressly subject to 27 and 21. My submission is, my lord, 26 is the SPC, 25 is the genus. SPC cannot have the wider area than it's a genus. So, my lord, just see the brief. Just see the brief. There is a brief. First page, my lord. दे रहा हूं सर, दे रहा हूं. The 9 judges bench of this honorable court will not only decide the 7 questions of law, but also decide the future of the country for next 7 decades. The interpretation of Article 25-26 will decide whether we would achieve the golden goals of the Constitution and become a united, integrated, and scientifically developed nation by 2047, or a radicalized country full of superstition, black magic, delusion, and dogmas. The sui generis case of Sabrimala is not being assailed here. Is it a long-standing custom which is in consonance with public order, health, and morality, and other provisions of Part 3? I have dealt in para 22, para 32, 30.
Straight come to the point, Mr.
Yes.
There is no
Then, madam, main argument. Just see the middle, main argument. Just, I request, madam.
That's right, but we don't have
Yes.
time.
You can summarize your.
We have to
Yes.
grant time to the others also.
The main argument, individual possess the right to propagate religion, while the denominations do not possess such right. The Constitution framers put the express restriction of the being subject to Part 3 in Article 25, while not doing so deliberately on Article 26, as Article 25 granted the right to propagate religion on individuals, while Article 26 did not grant any such right to any denomination or sections thereof. Even the anti-conversion laws enacted in the different states are based on the premise that only an individual can propagate, convert lawfully or unlawfully. The intent of the premise was also, as the root cause of the 1947 partition was denomination versus denomination conflict, not the individual versus individual conflict. Had persons propagated their religion peacefully, such a conflict would not have arisen. Notably, the 10 constitutions from which we adopted various parts of the constitution, neither back then nor even today have the conferred right to propagate religion on their citizens. Only after much deliberation was this right included in the constitution, with an express subjection to the other fundamental rights, keeping in mind its a dangerous nature. All the other articles are already impliedly subject to the other fundamental rights. Well, there is some argument. It was tried to connect Article 2930 with the Article 2627. My submission is this. Though Article 2930 have been tried to argue in this case, but they are not relevant in this case. Minorities were given certain protection in regard to their culture and education. Therefore, Article 2930 covered under cultural and education right. Had they been intended to confer religious right upon minorities, the framers would have not been made their heading to so exhaustive. Thus, Article 2930 are not to be dealt with in regard to right to freedom of religion and should be seen as completely distinct from them. The observation in few cases that Article 30 is an extension of Article 26 is therefore per incurium. My lord, petition is pending and before the refer to the 7-judge bench. Next, my lord, I have considered, my lord, few points. Number one, the dreams of the freedom fighters, the dreams of the constitution makers, the language restriction. My lord, Samvidhan is not the constitution. With utmost respect, I am saying. We don't have the proper words for Samvidhan. Samvidhan, samadhan vidhan. Yani sabke liye saman vidhan. Yani samyak vidhan. Constitution means vidhan. Because there is a limitation. In English, we have only 26 alphabets. We have total only around 10 lakhs words. In Sanskrit, we have 52 alphabets. We have around 50 lakhs words. And that's why, my lord, Honorable Dr. Ambedkar introduced a bill in the Constituent Assembly. Please make Sanskrit as the official language of Bharat. Unfortunately, that bill will fail, my lord. So when we interpret, my lord, things in English, it becomes very difficult, my lord. Similarly, Dharma and religion. I have not cited any previous judgment because the previous judgments are based on the assumption that Dharma is religion and religion is Dharma. It is totally different, my lord. My PIL is pending. Lordships have issued notice to the center also. I have requested to please introduce one chapter in primary. What is the Dharma and what is religion? I have differentiated 25 differences between Dharma and religion, my lord. I can summarize this. Dharma includes everyone. Religion excludes everyone. Others. Dharma unites society and religion divides society. That's why I have not cited the previous judgment because there are assumptions on based on Dharma and religion, my lord. Then, my lord, I have also considered, my lord, why this lord system came. We generally say, my lord, lordships. This came from the system of Panch Parmeshwar. Earlier we have the system of Panch Parmeshwar. 5 log बैठते थे, वो decide करते थे. And what was that vidhan? That was the Vidhi ka vidhan. And what is the Vidhi ka vidhan? That is the Samyak vidhan. That is the Samvidhan. So this is Samvidhan is different. Unfortunately, we don't have the exact word for the Samvidhan. We don't have the word for Brahmacharya. We don't have the word for Dharma. We don't have from word for yoga, etc. My lord. I also consider, my lord, there is, my lord, frequently said all religions are same. Not at all. Not at all. My third page is the 5 tenets of religions. I have given the 5 tenets of all the religions, my lord. Totally different. This is Ramayana. There is not a single sentence. You follow Ramayana, you pray Lord Ram. If you will not follow Ramayana, will not pray Lord Ram, you will go to Naraka. No, not at all. This is, my lord, विष्णु पुराण. एक वाक्य नहीं लिखा है कि केवल भगवान विष्णु ही पूजा योग्य है, विष्णु पुराण को ही मानो, अगर नहीं मानोगे तो नरक में जाओगे, नहीं लिखा है. ये भगवत गीता, एक सेंटेंस नहीं लिखा है, भगवत गीता को मानो, कृष्ण को मानो, नहीं करोगे तो नरक में जाओगे.
You are going beyond the subject and issue being discussed by every one of us. You said 52 alphabets in Sanskrit, one of the finest language in the world.
Yeah, my lord.
Similarly,
Yes.
Tamil has 247.
Yes, my lord. Yes,
So
yes.
don't go into all those areas.
No. What I am,
Confine yourself to the point in issue.
my point is, my lord,
Yes.
if you will interpret the constitution in English, then today we have the 9 judges bench, tomorrow we have 11. No in. If we will interpret considering it as Samvidhan, and what is the meaning, then we had different.
In Kannada, there are 52. So therefore, don't
Yes,
go
yes,
into
yes. No, all the Indians were, oh, sorry.
See, all
I am,
are equal.
I am
Doctrine of
sorry.
55.
I am sorry. All the Indian language have the 52.
Don't go into
52 alphabet.
superiority in the court of law, please.
No, my last submission is, this is Durga Sapsati. एक शब्द सेंटेंस नहीं लिखा है, केवल दुर्गा जी की पूजा करो, दुर्गा सप्तशती पढ़ो, नहीं तो नरक में चले जाओगे. Arya Samaj, also denomination, not a single sentence. Please follow Arya Samaj. Please follow. Very important, my lord.
Sorry,
Fit all this.
we have to stop you.
Yes.
It's not a public platform.
Interpretation.
My submission is this: Dharma and religion is not same, and all religions also not same. Entire world is burning due to religious conflict. Bharat was divided in 25 countries due to denomination conflict, religious conflict. So my submission is this, my lord.
Time is over, Mr. Upadhyay.
Yes, now I will only conclusion. Just see, my lord, conclusions. The conclusion, my lord, at page number 12. Article 25 is expressly subject to all other fundamental rights because it's conferred a novel right to propagate religion on individuals, unlike any of the nations from which we adopted our constitution. Article 26 does not confer right to propagate religion on religious denominations. The intent of the framer was never to grant right to propagate religion to religious denomination in light of the damage that was done by them before and during the 1947 partition and massive massacre. Article 26 is impliedly subject to the other provisions of Part 3 of the Constitution, like the other. Now, my lord, next conclusion on Sabrimala case, my lord. There are lakhs of mosques, but the Makkah, Medina have a distinct sanctity. There are lakhs of churches, but Jerusalem church has a distinct sanctity. There are thousands of Shiv temples, but Bharat Jyotirlings have distinct sanctity, my lord. There are lakhs of goddess temple, but 51 Shaktipeeths have distinct sanctity. Thousands of Jain mandirs, but the temples made on the birthplace of the 24 Tirthankar have different sanctity, my lord. Similarly, my lord, there are 1500 Sabrimala temple, but this temple has a distinct sanctity because no, Vice, my lord. I am saying that restriction on 10 to 50 is reasonable. So that's why I'm here, my lord. Because lordships are deciding the 7 questions of law, and I am supporting the Sabrimala case, my lord. That's why I'm this side.
Thank you.
Ma'am, just my lord. One conclusion, my lord. I'm only reading only conclusion out only, my lord. My lord, just see the page of 25. Conclusion.
Yes.
Article 30 was conceived by a framers of the Constitution as a response to the specific anxiety of minority communities, particularly in the shadow of partition, that the majority, through the instrument of state educational policy, might systematically erode minority languages.
Going to Article 30, that is not.
Because some argument was there that this is the, so I'm skipping lordships.
You are not responding to arguments. You are only giving your
Then my lord,
point.
just see the Dharma last page as page 35.
Now you have beautifully explained to us. We understood that.
My lord, the conclusion
Beyond
on
religion, you said. Yes, sir.
Dharma cannot be translated as a religion. Constitutional provisions touching upon Dharma must be interpreted with the conscious awareness of that distinction. Dharma is universal, reason-based, inclusive, ecologically balanced framework of duty conduct available to every human being, regardless of creed. It demands conduct, not belief, and draws to the boundary between believers and non-believers. Religion, as the term is understood in tradition from which its constitutional users derives its traditional bound, text-anchored, community-specific, and structurally exclusive. Its boundary between the faithful and the faithless has historically been a source of conflict and injustice. The Constitution is in foundational commitment, a dharmic document. Constitutional protections. I am only saying.
We argued on behalf of the respondent.
Well, just see.
Thank you.
Dharma gives liberty of thought, liberty of belief, liberty of faith, liberty of worship. Religion does not. Dharma says Vasudhaiva Kutumbakam. नारी तु नारायणी, सर्व मंगल मांगल्ये शिवे सर्वार्थ साधिके, यतो धर्मस् ततो जय. Religion does not. Religion says, if you are in my area,
Every religion has its own dharma.
my lord, with utmost respect, my lord,
Don't think that.
Right, we heard it.
all the religions don't give
Right, yes.
Vasudhaiva Kutumbakam concept, don't give one earth, one family concept, don't give Janni Janmabhumischa concept, don't
Well,
give
they have-
Sarva Mangal Mangale
That
concept.
is understanding. Please,
Kindly understand your responsibility.
please don't argue like this. Leave it there. Yes.
My lord,
This is absolutely,
It's not in good taste.
my lord,
Leave
it may be some bitter
No,
truth.
please, it's
It
not
may be
good
some
taste.
bitter truth.
absolutely not, Mr. Council. You have to understand the scope of this argument.
Don't with the limited understanding, please don't.
My lord,
Leave it at that. Or we heard
I'm
it.
only saying
Yes.
Article 25 and 26 gives freedom of religion, not freedom of dharma. Article 24, Article 14, 15, 16, 17, 28, 18 is the promote dharma. Article 19, dharma with some restrictions. Article 21 is dharma. Only Article 24 and 25 and 26 gives freedom of religion. Other rights, other fundamental rights are in the nature of dharma. So please keep in this mind, Mallas.
So
This is my humble
the
request.
rights will go. Only the religious rights will not be upheld.
No.
Already we heard it.
I am saying this Article 25 and 26 is the most restricted right. Most restricted.
We understood your argument is that rest of the fundamental rights are emanating from Dharma.
Yes.
Therefore, they have wider contour.
Yes.
They have wider meaning, and they are comparatively very stronger rights as compared to very restricted
Yes,
right
sir.
in 25.
Because it was argued
Because
that Article 26 has some different island. It was said Article 25, 26 is higher than even 25.
Thank you.
I am saying no.
Thank you, Mr.
Oblige,
Kaur.
Malak.
Thank you.
Oblige.
Thank you. Thank you very much. Yes, Mr. Dinesh. Yes. 2 minutes, please.
My lord's already granted me 10 minutes.
Just take the mic and straight start.
I will not repeat any single word which I argued by senior colleagues. It's altogether totally new points.
Take the
And my
mic.
lord, my submission.
Start straight to the point.
Yes,
And
my lord.
no reference to any note, etc.
Yes, my lord.
We will examine note. We have a lot of vacations,
Excuse me.
partial working days.
Partial vacation, partial working.
My lords, my submission, the crux of my submission, my lords.
You
If
take the mic first of all, you and straight start. Keep them here.
yes, my lords.
Don't give it. Yes.
My lords, if this rituals and custom is nothing to do with the religious cruelty, as observed by Justice Indu Malhotra in Para 8, then, my lords, the scope of judicial review is very less. My lords, may kindly come to page 76 of my note. Page 76 of my note.
Yes, please read that.
My lord, I will read.
Only one line with
Where is
the
your
punch
note?
line.
Where is your note, please?
My lord, page 76, para 3. It says that it is extracted from the judgment. The difficulty lies in applying the test under Article 14 to religious practices, which are also protected as fundamental rights under our Constitution. The right to equality claimed by the British under Article 14 conflicts with the rights of worshippers of this shrine, which is also a fundamental right guaranteed by Articles 25, 26 of the Constitution. It would compel the court to undertake judicial review under Article 14 to delineate the rationality of the religious beliefs or practices, which would be outside the ken of the courts. It is not for the courts to determine which of these practices of faith are to be struck down, except if they are pernicious, oppressive, or social evil like sati. So therefore, my lords, this is a dissenting judgment. This was my first layer of my argument for 5 judges bench, my lords. Now, my lords, may kindly come to page 14, quickly, my lords. What is the religious cruelty discussed by Commonwealth Assembly in 1858? In 1858, Commonwealth of Australia Assembly, debates page 14. Well, sometimes it will be extremely, and I want to read the executive order issued by the White House.
No, that we will not permit.
Yes.
Give to us, we will read it.
Yes, my lord. Now, my lord, page 14 at page 21, Commonwealth Assembly debates. What is religious cruelty? Edward Darden for Tasmania. I have an amendment to move on behalf of Tasmania and also an amendment to my own. The clause we have before us says that a state shall not make any law prohibiting the free exercise of any religion. It is quite possible that this might take lawful practices which would otherwise be strictly prohibited. Take, for instance, the Hindus. Well, it's the Hindu spelling is Hindos, that type. Hindus. One of their religious rites is sati, and another is the kachak, one meaning simply murder, and the other barbarous cruelty to the devotees who offer themselves for the sacrifice. Then again, yes, if this is to be the law, these people will be able to practice the rites of their religion. And the amendment I have to suggest is this insertion of some such words as this, but shall prevent the performance of any such religious rites, etc. Now, my lords, may come to executive order issued by the White House. Page 32, my lords. It's very important for my purpose. The executive order is always enforceable issuing by the White House. If the crux of that executive order at page 32, my lords. I'm sorry, my lords, it's at page 29. I'm extremely sorry. My lords, it's issued by George W. Bush, saying that your religious practice is very much relative to the society. If it is for social upliftment, if it is for self-purification, like Mandala Vrata in Shabrimala, and if it is for self-renaissance, that practice must be appreciated and part and parcel of the local laws. This is what the executive order issued by George W. Bush. Whether it is enforceable, which I gave a note at page 108. What is the meaning? How it can be issued? Enforceability of an executive order. Now, this is what my one area, that what is the religious cruelty? If it is not religious cruelty, and my practice is up for the upliftment of the society, and it is a self-purification, and it is self-renaissance, the court, the scope of judicial review is very, very less. That is what Justice Indul Malhotra's judgment. Now, my lords, may come to page 78, my lords. Now, I want to see a statistics. It is connected with the Shabrimala Mandala Vrata. Shabrimala Mandala Vratam is having with, like the same having with the Muslims. I have gone through the Holy Bible. Having with the Muslims, I have gone through the Holy Quran. I extracted those pages here. So, all this vratas is for the purification of the self-purification, and that self-purification is for the upliftment of the society that has to be appreciated under law and otherwise by the state also. And 25(2)(b), 25(2)(b) says social welfare. 25(b) says reform. That is what I am doing. Whether any cruelty involved in Shabrimala, there is nothing. But of course, unfortunately, a section of the people projected that religious cruelty is there. A section of the people projected that menstruating lady cannot enter into Shabrimala. No, I am going to prove it. I am competent enough to prove it. Menstruation or menstruating lady cannot enter into Shabrimala is absolutely wrong. That interpretation had been given by some kind of activist, and therefore, my lords, this menses projection is to misguide the court, misguide the society, and that is nothing to do with that. An effective understanding of Mandala Vrata will prove that it is nothing to do with this biological. That is why, my lord, out of 5 honorable judges, Chief Justice Mishra, Justice Kanvilkar, and Justice Sindhu Malhotra, out of 3, in this particular issue, decided on my favor.
Would you please answer the 7 question, anything to do with this? They are not hearing the
Well,
review. They are not hearing the review, please.
Then, my lord, then if there is no religious cruelty, I am not bound to give an answer. That's why I may substantiate this. I may, my lord, I will give that.
Please ask it.
My lord, I will give the answer because of my lord. My lord, there is
The time useful by they addressing the legal issue. We are
Yes,
not
my
going to that now.
It's
They already
legal,
said
my lord.
beginning itself,
The
we are not
three
going to-
judges' finding is absolutely legal and therefore it is bound to be Article 141.
That is with reference to the facts of that case, that we will examine, there is no issue.
Then, my lords,
Legal and law.
then, my lords, page 85. Why this mandala vrata designed accordingly for the men? And why a certain categories? My lords, kindly note it's only age relation, nothing to do with the ladies' entry. Page 85, my lords, types of prison inmates in central jails, 31st December, it's a crime record bureau. 96% of the men are committing the crime, only 4% under trial as well as convicts. And how this is at page 86, my lords, again, that tobacco consumption, alcoholic consumption, again with the men. My lord, I am coming to what is Mandala Vrata. It is nothing to do with the menstruation. We are pained by hearing this. We are pained. The entire writ petition says so. 2 honorable judges decided the issue on the basis of menstruation. Justice Nariman and Justice Chandrachud. Kindly see, is it a correct fact? No. That is why, my lords, crores of devotees are pained. So, tobacco, now, my lords, may kindly directly come to page 37. My lords, that is why the discussion between, because that's why I showed you that present details. Tobacco consumption, this is a family health survey by the government of India. I'm relying all the authoritative records. Krishna and Arjuna, this is what exactly says, my lords, page 37. Arjuna said, "O descendant of Krishna, now impelled by what does this man commit sin against his wish? As though driven by force." Man is not committing the crime, as driven by force. That is what statistics are very important. Now, my lords, again, the blessed Lord said, this lust, this anger, born out of Rajoguna, is insatiable and an awful sinner. Know this to be the enemy here, world, or in the embodied state. My lords, again, 3 pages are extremely important. So, therefore, my lords, that question of Krishna is extremely important. That is what the statistics we have seen 2023.
We understood that part.
Yes, my lords. So, now, my lords, page 38.
Anything on 20?
Page 91, my lords, page 91. My lord, this, my lords, make. I studied a lot, my lord. First day onwards, I was here.
Thereafter,
Yes, well,
Main case when
if I am disturbing my lords, I don't want to continue.
These are the arguments when the main case will be listed. Here you will have to raise all these arguments. You are unnecessarily preempting.
Yeah.
That's why my first submission, my lords, my first submission is, if there is no religious cruelty, and if it is an essential religious practice, then, my lords, whether I will come under the purview of 7 questions or not, at least if you understand this.
All right, that we have understood.
Now, my lord, page 90, my lords. Page 90, my lords, extremely important, my lords. 3 minutes more. My lords, this is Asian Journal of Medical Sciences. This journal of 5 doctors from different universities of the country gone through these 41 days vrata, Ayyappa Disha. Then they held, it's good for the power, it's good for sleep, good for the health, etc. So therefore, a social upliftment and self-purification mandala vrata is misinterpreted and misprojected before the society and says that because of menstruation.
You are an Ayyappa devotee.
My lords, Ayyappa is much more
Then
for me.
leave it to Ayyappa and leave it to us. We heard you. Thank you.
No, my lord, then one more point, my lord. One more point, my lord.
Yes.
My lords, that point is this, my lords. Legally, I have 2 submissions. I have legally two submissions. I said something on facts to counter this biological issue. Now, my lords, 25 2B, I already indicated to your lordship that social welfare, 2 minutes, social welfare and reform. I already submitted before my lords my respectful submission. It is social reform, Ramadan, that Sagat, that 50 days Noam as Jesus Christ observed Bible, like Mandala Vrata. So that is what its importance. Now, my lords, that 25 2B is clarified me. Now, my lords, 26 say, establish and maintain. Establish and maintain. In view of 25.1, in view of 25.1, I established something. Now, in 26, there are 3 important words: maintain, administer, manage. Why it is separately given? A, establish and manage. There are 2 parts. One is establish and manage. Maintain, I'm sorry. My lords, according to my respectful submission, my lord, Justice Sundaresh always wanted to legal issue. Maintain, Justice Vanchu interpreted 5 judges bench matter in connection with the Muslim University, Aligarh Muslim University. Page 71, which is that judgment. Maintain means continue. Dictionary meaning also continue. Interpretation of the highest court of the country also continue. So in accordance with the 25, I established something. I can continue it if otherwise proved that it is a religious cruelty. Now, my lords, just that, I will just read what we have said with Justice Vanchu's readings, my lords. I'm sorry, my lord. I understood that, my lord's problem, that all are here, my juniors are here. But I'm also, sir, what we, I'm sorry. I'm so not saying about you. You are much senior to me. But we have said with respect to Article 31, which gives right to minorities to establish and administer educational institutions of their choice, applies equally to Clause A of 26. And therefore, we are of opinion that the words establish and maintain must be read conjunctively, and it is only institutions which are related, but it's not. So it must be read conjunctively, establish and continue.
That is on 29 and 30, Mr. Biju. That
No, my lord, what court interpretation I'm saying,
Yeah.
my lords. That, my lords are absolutely right, my lords. With one more sentence, my lords. Kindly see page, my lord, last submission, my lords. It is not just Shabrimala. My lord, though I am just indicating Shabrimala, my general principle is what I am saying is,
there you are absolutely right. It is not Sabrimala only.
yes,
There are
religious
so
cruelty, religious cruelty. My lord, this in the premises of Shabrimala, there is a small mosque, Vavar Hundi. This is the only temple in the country, according to my limited knowledge, Vavar Hundi. And all the crowds of devotees going to this Vavar Nada, Vavar step, that small mosque is there. In the premises of Shabrimala, it is itself. So, my lords, whoever coming, Swamis, they are donating to this Vavar Hundi also. And Juma Masjid, Vavar was the friend of Ayyappa.
All
That
right,
is
thank
what
you,
the
my
last
lord.
way.
Thank you. That we understand.
And therefore, my lord, I am grateful.
Just
my lord.
2 minutes, Manoj.
Yes.
Two broad propositions only.
Yes, please start your.
Yes, Manoj. First is, Manoj, when 25 and 26 are pitted against. Please. I appear for one of the review petitioners, Manoj. I'm supporting the Sabrimala review. Now, Manoj, the question is when 25 and 26, either individually or together, when 25 and 26 individually or together are pitted against other fundamental rights, what is the approach to be taken? Electoral bonds case, your lordship, evolved the double proportionality test. The very first question which is posed in that test is when there's a balance to be done, is one right higher or the other right lower? But my submission is 25 and 26 together, individually separate, are not lower in hierarchy to any other fundamental right.
if there has to be an interference, it has to be in a pernicious case, not only sati or human sacrifice. Sometime back, reference was made to Colonel Borden for conversion. There was a judgment of Reverend Stanislaus, which was read out earlier. That was exactly a case where, my lord, interference is called for. Also, my lord, in Asha Ranjan versus State of Bihar, your lordships again considered when two rights are to be brought into conflict, or even within the same right, it does not mean that in the exercise of balancing, one fundamental right gets extinguished. No, that is what has actually happened in many of these cases. So, the submission is when the balancing has to take place, wide interpretation has to be given so that all the fundamental rights are given their full scope and play. One example of hierarchy could be right to property. It was removed from 19(1)(f) and put into 300(a). So, in that sense, it was demoted from a constitutional fundamental right to a mere constitutional right. So, if 19(1)(f) or 300(a) comes into conflict with any other right, then yes, one can say that there's a hierarchy, but not in this. Second point, my lord, very quickly, just taking off on denomination, what was argued by Ms. Diwan and Mr. Joshi and others, and some observations which fell from the bench. Shirur Math's judgment, my lord, is taken, the definition of denomination is taken from the Oxford Dictionary. Oxford Dictionary is essentially an English concept where the question is common faith, name, organization. This is follower specific. Lot of reference has been made, my lord, to specific temples in this country where specific worship is followed. But I would just like to take it a step further. Temples are consecrated, particularly our ancient temples at particular places for particular reason. For example, the Shakti Peeths. Worship over there is very specific to what has happened at that place. One example is the Jwala Devi temple in Himachal. Worship is of the fire. I am a Hindu, I can go there, but I will worship according to the rituals that are established at that place. I can't do anything else. I can also go to, let us say, the Jagannath temple in Puri. There the worship is of the idol. Again, I will have to follow the worship of that place. So being a Hindu or a section of a Hindu, the denomination should not be concentrated on me as a follower. It should be concentrated on the place where I am going to offer worship. In that sense, my lord, denomination has to have a much wider concept than what your lordships have held in Shirur Math and followed thereafter. Just to crystallize the point, if a particular place of worship is established for a particular purpose, the priestly lineage has a particular qualification, the rituals follow a particular pattern, then that particular place itself is capable of being defined as a denomination, not the person who goes there. That's the submission. That's all. Now, just with that note, on this point, there is a religious scholar who has written a note on that. I've just handed it up. I'm not going to read anything from that, but I just wanted to place.
Thank you.
Lord,
Thank you, Mr. Rohan. Thank you. Yeah,
A couple
please
of short.
announce your name also next.
Milords Anirudh Sharma. Milords Anirudh Sharma. Milords, a 9-judges bench has already commented on ERP. Hence, Milords, I must, on essential religious practices, in 2 minutes, I'll just place that, Milords, because that becomes very important. If my lords don't notice it, then, Milords, then it opens for 11 judges. Please, court pass.
You have
Milords.
given in the name in the list, then I will stop otherwise.
Milords, it's already there.
Now 2 minutes, please. Huh?
Yes, Milords. 9 judges.
2 minutes. Because your name is not there in the list.
Milords, speaking through Justice Ramaswamy in para 186. Milords Anirudh Sharma. Milords, 9 judges in Bomai. Justice Ramaswamy comments about essential religious practices. I have quoted it, highlighted it. I'll just read the highlighted portion, my lords. At page 1 itself.
Please,
My lords, in order to secure constitutional protection, the religious practice should not only be an essential practice, but also be part of an integral part of proponent's religion, but subject to state control. Otherwise, even purely secular practices which are not an essential or integral part of religion are apt to be quoted as religious forums and make a claim for being treated as religious practice. Then he again repeats in para 184, my lords, and then he says that no religious place can be stopped for any caste or any religion. As far as religion is concerned, there can be religious autonomy, not on basis of caste. One particular religion's place may have religious autonomy, so that, my lords, may have to reconsider, because this is 9 judges, it will bind. Second point, my lords, with respect to Bomai, next page, my lords. Again, it says entry only on grounds of caste or religion is outlawed. Next, not on gender. Though it, in my favor, my lords, this was also not the issue raised. So what was the issue raised, which will give the exact ratio, and the exact obiter therefore becomes crucial, because Justice Jeevan Reddy's judgment becomes the lead judgment, as every other lordships then agrees or disagrees with that judgment. What was the issue framed is 304 para number. My lords, what do these articles read together with the preamble signify? So he refers to 14, 15, 16, 25,
he takes a holistic view and says, what is it that it signifies? Then he holds, my lords, I have at page 3 stated that no other honorable judge goes into the issue of ERP. I give the para numbers of every honorable judge who deals with the issue. No one says even a single sentence about essential religious practice. So the question before Bomai was not essential religious practice. However, my lords, it creates an interface for future my lords where religious morality may conflict with constitutional morality. Bomai is a classic case of that. My lords, next point, my lords, the idea of binding effect of Bomai judgment. What is it that Bomai says, which I respectfully submit will also be binding on this honorable bench of 9 judges, my lords. Bomai says, first thing, that Article 25, 26, 28 constitutes one scheme, and 26, 27, 28 are just facets of 25. So if you don't have anything in 25, nothing works. But then 27 and 28 being part of it, the words in 27, 28 actually help in interpretation of Article 25. And in that, the first point is that there is an equality clause well within 25 itself. 25 uses the word equally, both horizontally as vertically. Equally, religion, individuals of one particular religion, there will be equality. And then when there is interface with the state, all denominations, all religions will be treated equally. Here also, there might be a problem, because if there is nothing in your religion, and if you are claiming, can you claim that equality? Your equality amongst religion will have to be first established that you have some part of it in your religion. Then only you can claim from state. If a particular thing is absent from your religion, there cannot be a formal and a very stale equality. It is a dynamic concept, equality between religions. First, religions will have to be investigated, and then equality will have to be substantiated. Next point is at page number 3. I have completed that. At page 4, a short point. That at para 183 of Bomai again, it says that the Constitution has made demarcation between the personal and the religious. This is Justice Ramaswamy's part, which is binding, because religion will come into the sphere of personal and secular will come in the sphere of public. Lords, then Justice Ahmadi also notices it. He also...
How did all this arise in Bomai?
My lords, because the issue...
Not to exercise of power.
My lords.
Article 356
My lords.
of dismissal of a state government.
My lords. Because secularism was held to be a basic feature question flame, so they analyze all the articles dealing with religious right and says what is secular and what is religion.
Secularism also arose under that exercise of power by the governor under Article.
My lords, but I would respectfully submit that all honorable judges in all the opinions of Bomai have dealt with secularism and the effect of Article 25, 28, 29, 30, 14, 15, 16 with respect to religious equality. And the core of that judgment is that everyone is equal within the religion and everyone is equal also outside the religion. And if that is violated, then the court steps in. The next point on this issue is what Justice Ahmadi says. He cites, I will not read, Hind Swaraj and Pandit Nehru's opinion. He approves Gandhiji's opinion. It says, religion is my personal affair. The state has nothing to do with it. The state will look after secular welfare, health, communication, foreign relation, currency, and so on. So for interpretation of the secular powers of the state, this comes into operation. What is secular? So this is the area where the states can interfere on the grounds on which the state can legislate under 25(2) on grounds of secularism and therefore can enter. To that extent, Milords. Milords, at page 5, the next point is Article 28(2). It has two important words, endowments and trust. It says that though the state may take control of a religious institution, but if it is established by an endowment or a trust for a particular religion, the religious instructions will continue even if the states take over. And this question was put directly to Dr. Ambedkar, that will it not be, will it not be a violation of secularism? So his views are on page 6, my lords. He says, permitting community which has established its institution for the advancement of its religion or its cultural life to give instructions in the school is allowed. The sum and summation of that is that you establish an endowment, you have a trust. So two things first. Under religious right, you must be having the right to establish endowment. Now, under 25(1). Number 2, trust. That is why the word persons is used in 25(1). And Dr. Ambedkar supports it by saying that the endowments and trust will have constitutional recognition by putting it specifically in the Constitution. So all those organizations which can come under 19(1)(c), under the definition of person, and this question was highlighted by my Lord Justice Sundaresh, that a question was framed in Shirur Mutt, but not answered. Hence, my lords, 28 gives the answer by giving substantial and direct recognition to endowment and trust. So 19(1)(c) comes. So, my lords, there are three categories now: individual, groups, and denominations. Those groups which may not qualify as denomination may still be having rights, and that is where, my lords, the third element comes into operation. My lords are sitting in the 9 judges. No judgment till now has gone into the third aspect in a 145(3) reference. However, my lords, in those judgments which are not 145(3) reference, they have gone. And my lords, I have just quoted Parsi Zoroastrian, those paragraphs which are relevant for this purpose. In my written submissions, I won't read it, my lords.
All right, thank you.
My lords, just last point, my lords. As far as, my lords, this, I have quoted Dr. Ambedkar.
But what is the third aspect? You have gone into.
My lords, first is individual, second is denomination, third is groups. My lords, a trust, endowment. An endowment is a pious person. In 30 seconds, I'll give an example, my lords. Someone creates a well of his own money. It becomes res extra commercium because it's dedicated to the society. Someone makes a temple out of his own earnings for the society welfare. Someone has a drinking system. My lords, these become rex extra commercium beyond the commercial view, and even the state cannot encroach upon it because state is parent entry. It always has to work in public interest. So someone has made out of his own money a pond, a well, a temple. All these are pious purposes. In Christianity, someone opens a church. In Islam, waqf. These are all pious purposes where you totally dissociate yourself from it and leave it for the general good. That's the last point, my lords. And my lords, as far as constitutional morality is concerned, I have just given some additional reasons in my written submissions, which have not been otherwise captured. So, my lords, to sum up, we have in Maharashtra, my lords, Ganesh Chaturthi. In West Bengal, we have Durga Pujas. In Bihar, my lords, and certain other places, other things. These are all arranged by the societies. They are pandals. So even in COVID, my lords recognized those rights and allowed them to carry on limited sphere. Those are not denominations. Those are neither individuals, but they have rights. So the third factor will be that even if I fail as denomination, or I'm a set of individual, even if I fail as denomination, I would still have some rights if I succeed in the test of evidence, my lords.
Thank you.
Much obliged.
Thank you. Thank you. For you, 5 minutes.
That's,
You asked for 5, granted 5.
Very grateful for that. So, my lords, I'll briefly state my 3 propositions. These are my submissions. My lords may read it later. I'm not relying on them for now. My first submission is that the test of hollowing out a religion or eviscerating a religion.
Take the other mic also toward you.
The first submission is that the test of hollowing out a religion or eviscerating a religion as the permissible limit to a 25(2)(b) legislation is both vague and confers the state with massive powers. Now, tomorrow, if a challenge is made to a 25(2)(b) legislation, my lords will have to decide what is hollowing out as per the tenets of that religion. Then my lords will have to make an analysis of what are the essential aspects of the religion and non-essential aspects of the religion. Then my lords will also have to decide whether the practice that the state interferes in results in hollowing out or not. Then the extent of interference results in hollowing out or not. This, my lords, with respect, my submission is that this is nothing but ERP test in a new cloak of hollowing out of religion test. In fact, this is much wider with much higher threshold, conferring the state with massive powers. In this background, my submission is, my lords should define the broad contours of state's power under 25(2)(b), lay down basic principles and some guardrails, which the states can do and cannot do in exercise of its power under 25(2)(b under the guise of social welfare and reform. I have suggested 6 guardrails. They are part of my submissions on the interpretation of 25(2)(b. I'll briefly state them. The first is that the expression social welfare and reform takes its color from and is guided by public order, morality, and health, to which the principal Article 25(1) is made subject to. Second is power under 25(2)(b) may be exercised to restrict, regulate, prohibit practices that are against public order, morality, and health. Third is power cannot be used to obliterate rights. Fourth is the literal meaning of social welfare is welfare of the society, which is relatable to public order, morality, and health. Reform presupposes an existence of a pernicious practice that does not include religious reform. On interpretation of non-obstante clause 25 2b, my lords, I have mentioned that this is contextual. This would mean that the individual right under 25(1) would have to be bypassed for social welfare and reform. However, the extent of interference or the substance of the legislation will still be guided by social welfare and reform, social public order, morality, and health. Sixthly, my lords, the power cannot be exercised to give effect to or in pursuance of a DPSP because that would destroy the fundamental right under 25(1). The legislation will also not be saved by Article 31C. Now, my second submission is what is protected under 25 and 26 are rights which are bona fidely and conscientiously held by the members of the community. Here again, my lords, if the community does not speak in one voice and there is difference of opinion among the members of the community for a particular practice, there again, my lords will have to wear a theological hat and decide whether the belief indeed is held bona fidely and conscientiously by the members of the community. The third point is on locus, my lords. The locus, I have stated very carefully that it has to be of persons who are actually aggrieved by the right. My lords should make it mandatory for the parties to plead in their writ petition that personal right to worship has been violated. Because I made a table of 23 cases that have been decided in the last 75 years, with the exception of Sabrimala and the triple talaq case where my lord Suomoto entertained a PIL, registered a PIL. There is no other case in which a PIL was entertained and decided by this honorable court in the interpretation of 25 and 26 right. Very grateful, my lords.
Serial number 9, my lord.
So I've been waiting for a long time.
If you can finish by
Yes, your lordship. I will take, lordship, my written submission is there. It's just a 10-page submission. And lordship, this is EA.
Start, Madam Kumar. Yes, start your point.
Yes, your lordship. This application pertains to Ma Kamakhya Devi Temple, which is in Assam, Guwahati. So I'm about the essential religious practices and the practices which are there, right, for a long time of custom. So I may just read the brief history, which is at page 5. The brief history of the temple, your lordship. According to Kalika Puran, when Shiva was going to Kailash with Sati, her father
deciding on individual temples, you know.
Yes, your lordship. What I'm submitting is that here there is no denomination.
Your religious practices, you can propound your point with reference to 25 or 26.
Lordship, what I'm submitting is, let me just start, your lordship, build up my argument. Lordship, this is a temple which is without a denomination. It is a rock, which is a cleft rock, and the shape is of the vagina, main vagina. Now, opposed to Lord Ayappan temple, this is a temple where menstruation is celebrated. There's a fair, there's Ambubachi Mela, and people as almost 25 lakh people. This is what I gathered the information, visit the Ambubachi Mela. Now, what happens during those 3 days, which are usually 22nd to 25th of June? The temple is closed. There are only women priests who are inside the temple. So what happens at large scale is Tantrism. So I'm on one of the practices which is widely practiced there, and it has all its vices. Tantrism, if done for a good purpose, has its effect. But Tantrism, if done for a purpose, which is only to indoctrinate one's mind, then it is certainly a practice which is to be stopped, at least at the public place. So if I may just read what is Tantrism, just the basic and the outline, it has got a panch karma, and panch karma involves what is known as 5M. Now these 5M are they're madhya, that is alcohol, mans, that is meat, matsya, that is fish, mudra, that is gesture, and method, that is sexual intercourse. Now tantric is not only male, they're also female. This is the latest. What happens is that when there is Tantra Vidya, like I will not relate it with any ism, but Tantrism is occultism, which has got a lot of practices which are opposed to human life. It violates Article 21 because in Ma Kamakhya temple, there has been a practice of human sacrifices. When human sacrifice and when the temple door opens, it opens with the sacrifice of an animal. So this is a practice which is conducted, and lordships have, in a judgment of this honorable court, there has been a judicial deliberation on who will manage the affairs of the temple. So one is Tantrism. Second is that, again, the free access. So for 3 days when it is closed, it is fine that, 3 days may it be for whatever purpose. But what happens is that who are discriminated are the male. If there is a women priest inside and there are also sadhus who are allowed inside, then why not a women pilgrim? So this is one of my point which I am saying.
This side or this side, madam. First of all, we should.
No, Lordship, what I'm saying is that like Lord Ayappa temple, there's one particular practice which was not there, that was opposed to the temple of entry of women. Here there are three things. One is the animal sacrifice. I said this is in direct violation of Cruelty to Animal Act. This honorable court has also heard matters relating to wildlife. And there's one particular temple in Kerala where elephants open the temple with, they worship. It is elephant who worship first. So there was a particular time when elephant cannot be transported. And if elephants
is run by whom? Kamakhya temple is run by whom?
It is a trust. It is a trust. Borderiers.
You are not representing the trust.
Lordship, the trust, there
I understood your argument.
no, Lordship, may I just point out, Lord,
It is not a trust, it is run by tradition. There was a conflict that took place.
in 2015.
Stored the traditional managers of the temple.
Lordship,
There is a litigation.
Lordship, Dolis took over, yes. Dr. Dhawan is correct, he argued. This is 2019, 2015, volume 9.
We are not going into this dispute, madam. That's a separate.
Lordship, I'm on some practices which are continuing.
We are not on practices, please. We are on 25, 26. If you want
Yes,
to add anything,
yes,
online, you
Lordship.
can speak, otherwise, oral.
Yes, Your Lordship.
Thank you.
Lordship, Article 25, 25 2B is the controlling or is the guiding article to Article 26. Article 26 is about the management. Article 25 2B is about the individual right. I as an individual devotee or I as a pilgrim, when I go to Ma Kamakhya temple, those 3 days, people who are permitted are those, which is, there's a big mela. So the population which actually goes to that place is much more than what is the size of that hill. So what practices are done there, and the animal sacrifice, because I've personally gone there and I've seen every 10 minutes, there's some animal which just cries. But what is shown on the YouTube, if we go by the
We
media.
understood you should have been decided in all fairness.
Yes,
We are at-
Lordship,
We are at,
last,
we are at serial number
Lordship,
9.
last limb of argument, Lordship, just one
So
second.
again, in the name of 26, you are again coming to some practices there.
We are at serial number 9.
May I
I
just,
understand very well.
Lordship, may I just
You
argue
can
my
sit here.
may I just argue my last point? And this animal sacrifice, which Lord.
Now stop this animal
Please.
sacrifice.
Please, we are not into it.
We are not into it. Thank you.
We are at serial number
We are
9.
giving
After
you
lunch.
Lordship,
5 minutes time.
Lord- Lord-
Your argument is over, madam.
obliged, Lordship.
Thank you.
But my written submission is at volume 1.3. I will not take more than 10 minutes, my lord. 1.3. Kindly have a note. And I have summarized it in only in 2 pages, my lord. Now, my lord, we are concerned with the reference number 6, which says that sect of the Hindus. Now, my lord, the word Hindu has not been defined in the constitution or any act relating to the Hindus. First time, my lord, a constitution bench in 1966, Yogi Raj case, my lord, kindly have my written submission, my lord, or the notes which I have just passed on, my lord. Only one paragraph I will read, my lord. The constitution bench 1966, it is, my lord, followed by the later benches, and in Sabarimala case, Justice Chanchud has also, my lord, relied on this judgment. Now, kindly see, my lord, what the court says. It just, my lord, I'm reading the relevant paragraph. It does not claim any one prophet. It does not worship any one god. It does not subscribe to any one dogma. It does not believe in any one philosophical concept. It does not follow any one set of the religious rites or performances. In fact, no, my lord, it is irrelevant. In fact, it does not appear to satisfy the narrow traditional features of any religion or creed. It may broadly be described as way of life and nothing more. Now, kindly see, my lord, the first time the definition of the Hindu has been attempted to be made by the Constitution bench. With great respect, I submit, my lord, this definition is not correct, and it is being followed by the later benches, and Justice Chandrachud has also followed it. Now, kindly have, my lord, one relevant paragraph of the Keshwanand Bharti case, I have extracted it. Paragraph 651 of the Keshwanand Bharti case, where, my lord, a very beautiful example has been given of the religion and the constitution in regard to the basic feature of the religion and basic feature of the constitution. Only one paragraph, I will hurriedly read it. Our constitution is not merely a political document. It is essentially a social document. Like every religion, it has 2 main features, basic and circumstantial. The former remains constant, while the latter is subject to the change. The core of the religion always remains constant, but the practices associated with it may change. Now, my lord, I pause. Now, my lord, this case says that the religion has also two my lord, compartment. One, basic features, and another circumstantial, which goes on changing. So the earlier division of our constitution bench, which says that it is way of life, with great respect, I say, my lord, it is not correct. Now, the question arises, what is the core of the basic feature of the Hindu religion? You know, this attempt has been made several times, but no one has successfully propounded that what is the Hinduism, because your lordship is hearing, your lordship has heard enough on this subject. My respectful submission is slightly different. This nine-judge bench can not attempt to make a definition of the Hindu by taking the advantage of the Bhagavad Gita. Bhagavad Gita came much before these, my lord, the essential practices which has been, my lord, described before your lordship. Now, the Gita is safe for 2 reasons. Number one, a large number of the commentaries have been made on this subject, and there is no conflicting view on the Bhagavad Gita. Otherwise, in the Upanishad, Vedas, and all these Smritis, if we go, there is a lot of conflict. Reason-wise, there are different practices in the country, and so one core Hindu religion cannot be, my lord, defined except the aid of the Gita. Now, my lord, kindly see, I will cite only 2 verses of the Gita, which shows that our constitution, the fundamental rights, and some other philosophy has been taken from the Gita. Now, my lord, kindly have my notes, my lord, chapter 5, verse 18 says, my lord, I'm reading only English translation. The wise see with equal vision a learned and humble Brahmin, a cow, an elephant, a dog, and even an outcast. So Article 17 of the Constitution is very much there in the Gita itself in chapter 5, verse 18. Now, similarly, my lord, the equity we can found chapter 9, verse 32, which English translation says, my lord, O Partha, even those who are women, Vaishyas, Shudras, or sinful birth attain the supreme goal by taking refuge in me. So these, there are several other, but due to lack of time, I'm not citing those. I have mentioned all these, my lord, in my written submission, which is at 1.3, volume 1.3. Now, my lord, kindly see, my lord, the Hindu word, which we have been told that it has come from the foreigners, because the people who are living across the Sindhu, they are called Hindu. Now, kindly have my written submission, my lord. Just, my lord, last paragraph, I will not read further. Hindu. My lord, the Chinese traveler, Yu Zheng, who came much before 3 EC, he says that these people are the Indus. He found this word Indus from the moon, because the synonym of the moon is Hindu. Now, since Lord Krishna in chapter 15, verse 15 has says that I live in the every living being's heart. So the Chinese traveler says that these people who are living beyond, who are living in this country, they are governed by their heart. And word he has taken from heart. So he says Hindus. And later on, these foreigners have taken this word and has redefined it that the people who are living beyond the Indus are Hindus. This definition has come much before the foreigners has given this definition of the Hindu to us. That's all, my lord.
Thank you, Mr. Vagel. Thank you. Thank you. Thank you.
May I with
Para
my lord's-
F, my lord, kindly have the para F of my written submission. I'm not reading it.
Thank you.
May I, with my lord's leave, make my submissions, my lords? I'm in 901.54, representing the Akhila Bharatiya Ayyappa Seva Sangam, my lords.
Come to our mic side, madam.
I will make two submissions and one pertinent clarification, my lords. My first submission is this, my lords. Across religions, in the path of devotion, every religion prescribes this adherence to austerities or vrata as an effective tool for God realization or liberation, my lords. You know, every vrata has its own set of yama and niyama, that is do's and don'ts, my lord. Insofar as the Sabarimala vrata is concerned, every devotee who desires to have the darshan of the Lord must adhere to austerities for one mandala, which is 41 days. And thereafter, he becomes eligible to carry the irumudi, which is the holy offering to the Lord, and then only ascend the holy 18 steps, my lords. It often happens, my lords, that even men who have undertaken the penance, my lords, during this...
Pass on what you're saying.
Oh, sir, I'm so very sorry. I'm so very sorry, my lords. Even during observing the vrata, my lords, what happens is if a man loses his, unfortunately, parents or wife, my lords, he has to necessarily stop the vrata. The holy Tulsi Mala that he takes on the initiation of the vrata, at the inception, he has to give it up, my lords, and his vrata comes to an end. Therefore, my lords, my humble submission is this, that the niyama of the Sabarimala vrata mandates that any devotee who is desirous of the darshan of the Lord must undergo this 41-day period vrata, my lord. So any person who is not able to fulfill this vrata, regardless of a man, as he will, when in situations when he loses his parents or wife, my lord, they cannot be permitted to enter the shrine. Therefore, my lords, my respectful submission is if the petitioners, the women are allowed entry, that would amount to modifying or in fact destroying the yamas and niyamas of the vrata itself, which cannot be done under 25(2)(b or any other state action, my lords. My second clarification, my lords, is much has been said about sati. I have with my, my lords, compilation, annexed the Bengal regulation of 1829, my lords. I would only read the opening paragraph of the regulation itself, my lords, which is at page 23. If my lords may kindly have. Page 23 is section 1 of the Bengal Sati Regulation 1829. My lord, this categorically declares the practice of sati or of burning or burying alive of the widows of Hindus is revolting to the feelings of human nature. It is nowhere enjoined by the religion of Hindus as an imperative duty. So it was never a religious practice, my lords. And then 4 lines thereafter, these acts of atrocity have been perpetrated, which have been shocking to the Hindus themselves, and in their eyes, unlawful and wicked. So even to the Hindus, it was unlawful and wicked. My last submission, my lord, is I would respectfully draw my lord's attention to the revered author, H.M. Sirvai's critical analysis of the Constitution of India at page 5, my lords, paragraph 12.41, where, while dealing with the rights under 2526, the learned author says, again, the violation of a right to enter a denominational temple has to be judged in the context of the law under which the right was claimed. My lords, over the page, the learned author refers to State versus Puran Chand. Over the page is a case which arose in the year 1950s, my lords, when Puran Chand is the pujari of a Jain temple. He did not permit a Dalit, Hindu Dalit, to enter the Jain temple, my lord. Therefore, he was sought to be prosecuted under the Untouchabilities Offences Act 1955. Having regard to the language of section 3 and the explanation, which says that every Jain is deemed to be a Hindu, the question arose as to whether he has committed any offense. The trial court convicted him, but the appellate court, my lords, over the page at page 7 is very relevant, my lords. Para 2, last 3 lines. The learned sessions judge interpreted the explanation differently, holding that, according to the explanation, although Jains would be treated as Hindus, Hindus could not be treated as Jains. My lords, in the last paragraph, the complainant in this case is a Hindu, and therefore it was necessary for the prosecution to establish that the particular temple was open to non-Jain Hindus in general. The argument advanced by the learned government advocate that a temple exclusively open to Jains should, in the light of explanation, be deemed to be open to Hindus in general, and Harijans should be admitted in such temples does not appear to me to be correct. The object of the provision is not to create any new rights in favor of untouchables, but it is intended only to put them at par with other caste Hindus. Drawing analogy from this, my lords, my respectful submission is, if the writ petitioners are believers, such as the devotees who are the review petitioners before my lords, if they are standing on the same footing, my lords, number one, they would not and should not question the yamas and niyamas of the Sabrimala Vrata if they are believers. And if they are non-believers, they don't, as a matter of right, claim entry into the temple, my lords. That is all my sir.
Thank you, Madam Shobha. Thank you. Thank you.
May I please, your lordships? I am appearing for All Kerala Brahmin Federation, which is a review petition of my lords. Lordships, may kindly, I'll not take much of your time, lordships. Kindly have a look at the structured submissions, my lords. Yes, please. May I first, I'm Abhilash, I'm appearing for just 2 minutes.
Just follow like Madam Shobha has been very brief and to the point.
Yes, yes, my lords.
Thank you.
My ladyship had raised a question, my lords, as to what precisely is the sui generis nature of Sabrimala temple, though the learned solicitor had responded at that time by virtue of me hailing from the same taluk where the temple is situated. Let me make a short submission, my lords, that Sabrimala temple happens to be the final hermitage of Lord Ayyappa. In other words, my lords, Ayyappa is theologically believed to be residing in Sabrimala temple. Unlike all other Ayyappa temples, his physical manifestation is a religious presumption. My lords, apart from that, there is a specific place named Mani Mandapam, which I kept as appendix, a photograph, my lords. Mani Mandapam, which happens to be the Jiva Samadhi of Lord Ayyappa. On account of all these reasons, Sabrimala temple happens to be sui generis on account of the theological faith that Lord Ayyappa resides there. Lordships, kindly have a look at the first question which I have discussed, my lords, on page number 1. What is the meaning and scope of the expression? All persons are equally entitled under Article 25(1) of the Constitution of India. In my humble submission, this is an aspect which has not yet been dealt even under Shirur Mat, my lords. I'll take your lordships through the submission. It is respectfully submitted that the Constitution draws a clear and substantive distinction between the expression all persons in Article 25(1) and every religious denomination or any section thereof in Article 26. The use of the expression all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion implies in clear terms the right conferred as an entitlement to all persons to practice religion. In other words, rights available to a person shall be exercised in such a manner that the equal entitlement conferred on others shall not be affected. A single person cannot constitute a religion, and it is essentially meant for a group of people in case of a place of worship. Hence, any claim of entry to a place of worship following a distinct set of rituals and practices like Sabrimala can be recognized only in consonance with the customary practices associated with the deity, because entitlement is equal to practice religion. It is submitted that Part 3 of the Constitution confers rights on 4 categories of people for the purpose of classification: person, all person, citizens, all citizens. A chart of classification of rights conferred under Part 3 is presented herewith. Kindly have a look at page number 2, my lords. I have classified rights conferred on person, all persons, citizen, and all citizens. And Article 25 happens to be the only right, my lords, which is conferred on all persons. Thereby, meaning when a person is seeking to exercise his right under Article 25, it shall have to be necessarily exercised in consonance with the rights of other members of the community. Article 26 talks about every denomination, whereas Article 25(1) is categorical and clear that all persons are equally entitled. In my humble submission, it's essentially a collective right. While protecting the right of every single person, it shall have to ensure, the right ensures that right to practice religion is protected. Lordships, kindly have a look at question number 2, my lords, whether the enabling power under Article 25(2) of the Constitution can be invoked to justify actions by state authorities that result in violation, dilution, and destruction of long-standing customs and usages integral to the religious practices of a temple. Lordships, I understand that this happens to be the greatest deliberation on Article 25 since Constituent Assembly debates got concluded. The scope of Article 25, when your lordships are deliberating upon, may necessarily have a glance, may necessarily touch upon this aspect, my lords. Quickly, I'll read. It's respectfully submitted that Article 25(2) of the Constitution, which enables the state to regulate secular activities associated with the religion and to enact laws for social welfare and reform, cannot be construed as conferring any authority upon the state or its instrumentalities to violate, disregard, or destroy the established customs and usages of the temple. The provision is enabling in character and operates within the constitutionally defined limits. It does not authorize administrative authorities to act in derogation of the rights of the believers under Article 25(1) of the Constitution of India. For instance, a political party having atheistic ideological foundation may ascend to power in a state and may appoint a non-believer as Devaso minister or official. The state minister may, despite strong atheistic belief, step into the temple premises or in front of the sanctum of the temple where religious activities are performed and can act in a manner irreverential to the customs and practices. The person holding authority under the state may stand in front of sanctum and stare at the sanctum without any customary salutation, or may receive holy water from the sanctum offered as prasada and may pour it down on the floor or may dispose the holy water with irreverence. The question that arises here, my lords, is whether the right under Article 25(1) extends also to the extent of protecting the sacred practices and customs from state intrusion under the guise of authority under Article 25(2)(a). This may be answered by issuing appropriate guidelines or observations. Lordships, kindly have a look at page number 5, my lords, whether the exclusionary practice in question based on the concept of youthfulness is based on the concept of youthfulness of women rather than the notions of fertility. It was advanced by senior counsels who argued previously that the notions of fertility is significant here. Because of me hailing from the same place, my lords, after having been associated with this practice for quite long, it's not fertility but youthfulness my lords, that is fundamental. Lordship, may I kindly have a look at page number 6, my lords. Whether for the purpose of Article 26 of the Constitution of India, the existence of a formal structure such as organization, endowment, etc. is necessary precondition for recognition as religious denomination. The issue is very much answered, my lords. I am not further touching upon that. Nevertheless, my lords, there are two examples. One is that of Naga sannyasins, which form a very loose conglomerate. There are different akhadas or monasteries, my lords, which are associated, which are organized under the general name of Naga sannyasis, like Niranjini, Juna, Nirmohi, Udasin. These are all monasteries, but there are such practitioners who are not formally classified. Nevertheless, they claim their distinctive legacy and they also deserve protection without being formally organized, my lords. Likewise, there is a Sampradaya named Nath Sampradaya, which happens to be a very broad theological set of practices and beliefs. And under Nath Sampradaya, there would be certain organizations like Self-Realization Fellowship, like that of Paramahamsa Yogananda. But there are large number of, I myself am an initiated disciple of that particular sect, but there are large number of practitioners of Nath Sampradaya who are not formally organized. On account of the peculiar practices, they also deserve protection, my lords. Then your lordships, if may come to page number 8, my lords. Is Sabarimala a Hindu temple in the light of the people belonging to other religious communities offer worship here? This was advanced by Leonard Senior Counsel Gopal Shankaran Narayan. He stated that Sabarimala is not a Hindu temple, but just let me take through that provision, my lord. Sabarimala is a statutorily recognized as a Hindu temple under Travancore Cochin Religious Institutions Act of 1950. Sabarimala temple is included under Schedule 1 of the Act as ordained under Section 2C that provides for incorporated Devaswams. That means Devaswam mentioned under Schedule 1. Hence, the eclectic nature of worshippers in Sabarimala does not denude its essential character of being a Hindu temple. It is also submitted that over 95% of the pilgrims in Sabarimala belong to Hindu religion. Lordships, my detailed written submissions are there. I am highly grateful that your lordships.
Thank you, Mr. Ullah. Thank you.
Heard me.
I will not take.
Spell your name also so that sometimes.
Lordship,
Yes, you.
my name is Dr. Shayan P. Shashidhar. I am for Akhila Bharatiya Malayali Sangh.
Yes, please quickly.
Lordship, I restrict to only indigenous people and it's related to 25 and 26, which so far nobody is addressed that part. Lordship, there is more than 700 indigenous people or ethnic groups are there in India. And these entire ethnic groups got their own belief system. And they are addressed as Adivasis, Girijan, Vanvasi, Giri work in multiple names. But our constitution identifies them as only scheduled tribe. And the scheduled tribe definition is there in 366(25). Read along with Article 342, and also it should be read along with CO 22, which is called Scheduled Tribe Order of 1950. But Lordship, if we keep all these things together and read, then also the scheduled tribe definition is ambiguous. And this honorable court in multiple instances, multiple judgment, it is been directed to the government that make an unambiguous definition for scheduled tribe. Lordship, this ambiguity which is coming because of the term tribe. Our constitution, it's more than 40 times it is repeated in tribe the term, but it is not anywhere it's clarified what is a tribe. And this tribe word in multiple instances, multiple judgments, this honorable court bring it into a definition form, which is started with a state of Kerala versus Chandra Mohan, which was the initial, that was on 2003 judgment. It was a 3 judges bench. In that one, common delight and cohabitants, etc., were the main characteristics of this tribe witches. And Nyagiri judgment, one of the important judgment, it is a 3 judges bench again. it is also called that Orissa Mining Corporation Limited versus Ministry of Environment and Forest and others. This judgment was on 2013. And Lordship, the recent judgment, which is of 1 month back, Justice P.K. Misra and Justice Manmohan bench, which is, there was one judgment which is called Chindada Anand versus State of Andhra Pradesh. This is even cemented the tribe, what is tribe, to bring a definition for the tribe. Lordship, what I would like to say is, tribe is a tribe because of their practices. Lordship, the practices which are of 3 types of practices. One is cultural practices, customary practices, and ritual practices. Or we could say that cult. Cult in the sense it's of traditional practices as well as ritual practices. These all 3 together, these 3 practices comes through together, then only a tribe become a tribe. That's what this court itself is saying, and that is, I agree with that point. Lordship, about the tribe, it is not only a constitutional obligation. There is an international obligation also for India. See, there is various convention and submits which I mentioned in this one. That's on Earth Summit 1992 and Biodiversity Convention, which is in again 1992. And
what do you want to say, submit?
What is your ultimate argument with reference to
practice which deals or which identifies a tribe?
Practice identifies, it defines a tribe.
Yes.
Therefore, that should not be disturbed.
These practices are, my lord, these practices are connected to the faith. These practices are connected to the religious system.
I understand.
Okay, my lord. So this one is essential practices theory, which cannot be applied to this tribal perspective.
Understand.
Okay.
Understand that your argument is.
And one more, but just one point. And comes to Article 371A, which is a special provision which is given to Nagaland, state of Nagaland, which clearly states that notwithstanding anything in this constitution, no act of parliament in respect of religious or social practices of Nagas, Naga customary law and procedures, Naga administration of civil and criminal justice involving decisions according to Naga customary law. Lordship, what is my doubt, I ask myself, is when one organ is restricted from interfering into the customary law or customary practices, whether another organ whether could involve into or interfere into that particular practices. This is what
Thank you. We understand. We appreciate your argument.
My lords, I'm arguing from the lens of self-determination. And I'm arguing from the lens of self-determination in Article 25 and 26. There's a 2-page note on self-determination that I'm transferring. This is for, and this is for this side, my lords. There's a 2-page note on that new proposition of self-determination. I would just request my lords to take note of that. I'll start my submissions, my lords. The Constitution of India is the single most extensive statement of self-determination made by a sovereign state in known history. Through our founding mothers and fathers, we the people in Article 25 and 26 also encoded covenants in Article 25 and 26 describing and determining our religious identity. If my lords were to look at the Hindi constitution of Article 26, religious denominations is called Pratyek Dharmik Sampradaya ya uske kisi anubhag. This definition is wide enough that on one hand, it protects formal worship as seen in the Ramakrishna Mission case, and on the other hand, it protects those indigenous practices and unique practices or worship of Prakriti and nature as seen in the Niyamgiri Hill case. Unlike the present understanding of denominations, which we see in a formalistic sense, the determination of religious practices, my lords, has evolved in 6 phases. What started from Shirur Mat and Ratilal Panchanand on essential religious practices has now reached constitutional morality in this case. Point number 4 of my submission is that evolution of the law and the cases mentioned. This expansive reading, my lords, I submit, has reduced the right and denuded the right of the community to determine its own practices, which has been recognized in Shirur Mat and Ratilal Panchan, thus requiring reconsideration to bring it back to the hands of the community. This reconsideration, however, does not preclude judicial intervention, judicial review, and also does not restrict or make Article 26 absolute, as we've seen in the Constituent Assembly debates also. And is subject to regulation. This extensive reading into the silences defeats the text when we see it from a lens of self-determination. And this needs preservation. However, my lords, I do emphatically submit that the intent and conclusions of Venkatramana Devru ought to be upheld and preserved and protected. Now, my lords, to this extent, the conjoint reading in SP Mittal, unlike Shirur Mat, which was disjunctive in nature, upholds the narrow straitjacket view of denominations. This precludes a protection that would otherwise be granted to indigenous communities and people. Similarly, my lords, in Article 25, when we look at the term section of Hindus, it reads as Hinduo ke sabhi vargo or anubhago ke liye. This, my lords, has to be seen in light of its historical context and cannot be seen in light of gender, because if seen in light of gender, it would also affect and denude practices of those spaces that belong exclusively to the feminine and the third gender, which is governed by their respective rituals. Now, my lords, before I progress, just if your lordships could look at my note in footnote number 2, there is an explanation to other secular activities, my lords, that comes from the Dakor temple case, which had shown what secular really means over here. So if an argument is made that secularism should be seen in Article 25, that would not cover within the ambit of Article 25(2) and other secular activity. This last to say, my lords, this honorable court is providing a judicial nuance to this encoded self-determination. This will reflect the constitutional promises made to communities and for generations to come. I'm grateful for the patient hearing, my lords.
Thank you. Yes, please. Yes.
Grateful.
Yes, thank you.
I'm Krishna Raj. I'm Advocate Krishna Raj. Item number 901.
Two mics at least.
I am Advocate Krishna Raj. I'm representing 901.62 and an intervention application.
Yes, please. Yes, please.
Lord, I passed on the notes. Two copies. Are there. Volume 1 and 2. Lord, the
आगे सर्कुलेट करते हो तो यहाँ रख के बैठ जाते हो. Yes, please start.
Yes, Lord, the first point is, Lord, about the civil right of the deity. Lord, what am civil right of the deity, Lord? Lord, it's an admitted fact that the property wherein the temple is situated, Shabarimala temple, Lord, belongs to the deity, because in all the revenue records, admittedly, it is recorded as the property of Shabarimala Devaswam. Now, Devaswam means property of the Devan, deity. So, my lord, property belongs to the deity. So, my lord, as a juristic person, in the 5 judges bench, my lord, there is a discussion to the effect that, my lord, even though the deity is a perpetual minor considered as a juristic person, there is, since it's a fictional character, my lord, there cannot be any fundamental rights. But that's why yesterday or day before yesterday, Lordship has asked about the application of Article 21. So, my humble submission, my lord, as far as the deities are concerned, it's a prana pradishta, my lord. In my compilation, my lord, I have clearly, my lord, in paragraph 5 onwards,
yes,
volume 1, my lord, 5 onwards, I have clearly, my lord, mentioned all the prescriptions of construction of a temple and installation of a deity, including it starts from the selection of a property. Because even each and every property emanates, my lord, energy, whether it is positive or negative. It starts from there, and ultimately, my lord, it covers paragraph 7 and 8, and when it reaches, my lord, paragraph 9, my lord, and paragraph 10, it explains the prana pradishta, how a deity is installed, my lord. My lord, may I just read, my lord, paragraph 10, 2-3 lines. Lordship has got it, my lord. After the material for the deity is selected and the idol is made, the procedure for consecration starts. At the time of the installation of the deity, the tantri of the temple will give life to the deity from his own body through the mantra which is selected according to the bhava of the deity.
Proposition. What is the proposition?
Proposition of the deity is a living person because we are giving food to the deity 3 times a day. So deity is a living person, and therefore, my lord, deity has got a constitutional right as well as a civil right. So as far as civil right is concerned, my lord, deity has got a right to decide whom to enter the property. He can select the persons. So, my lord, the wish of the deity and will of the deity is determined by, my lord, Deva Prashna. It's a ritual called Deva Prashna. There are 3 Deva Prashnas wherein the wishes of the deity is clearly stated. It's clearly stated that, my lord, the women. Then as far as the ritual is concerned of restricting the age group, my lord, I have stated, my lord, in paragraph, first may I have kindly have a look at paragraph 13. It starts from paragraph 13 because each and every, my lord, there are 18 steps reaching, that's called holy steps, my lord. No, what I am saying, my lord, the ritual is nothing to do with, my lord, this menstruation. That is what I am saying. What I am submitting is, my lord, the 18 steps of, my lord, is each one, every ritual of human being, my lord. When you enter the steps, my lord, the virtues are dissolved. And when we reach the temple, my lord, it is called Tattvamasi because we are laying with the deity. So then Lakshmi, have a glance at volume 2, the intention of this entire process. Lakshmi, have a glance at paragraph 7. Not after, not merit. Regarding the locus, regarding the locus, my lord, the entire issue started from Shabarimala. That's why, my lord, there is a speciality of the temple that's submitted. Now, Lakshmi, have a glance at, my lord, the volume 2, my lord.
When we take up the main case.
I understand. Just one submission. My lord, after the judgment of the 5 judges bench, my lord, there is permission for the ladies to enter the temple. And there was even after on the reference made to this bench, my lord, there was no stay. Only, my lord, 2 ladies entered the temple with the help of the police. And, my lord, there were attempts to enter the temple by another 3. My lord, I have given an entire list. All are declared atheist. So the intention is very clear. The intention is very clear. My lord. There are not, my lord, declared atheist. I have given the description of the entire people.
Well, thank you, Mr. Krishna. Thank you. Thank you very much. Thank you.
Please, Your Worship. I'm appearing in 966. This is the matter where entry of Muslim women in the mosque is being regulated. Your Lordship, 2 facts. Firstly, the mosque in question is merely a public trust. It's a public charity. So it won't be amenable to a writ jurisdiction under Article 12. That's the first proposition. Second proposition, we as a regulator of Waqf Board cannot interfere into their domain, cannot interfere into their religious affairs. So that's the second proposition. Now, the petition actually is canvassed as if to say that it's the obligation or the right of a woman to go and offer namaz in a mosque. Now, what that would happen is, Your Lordships, I have carved out in my submissions, page number 4, I have juxtaposed Muslim males' obligation to perform namaz with the privilege of a Muslim woman to perform namaz. Could Your Lordships come to that? Page 4.
Yes, please. You can.
I've said that Muslim male.
Issue now.
Well, I'm just
confined yourself to only 7 questions raised here.
But based on this, I'll come to it. What I'm saying is that a compulsion on a husband or a man cannot be made as an obligation on the woman. If we were to say that she has to go, we will actually be saddling her an onerous task which her religion does not. Now, with that, Your Lordship.
What is the prayer in this petition?
The prayer in the petition is that Muslim women should be permitted to enter the mosque. That's the first prayer. Second, the prayer is that they should be allowed to perform namaz there. Now, that they themselves admitted that it's not prohibited. But if we were to allow something like, who would regulate it? Either Union of India, state or Waqf Board would regulate it. Now, we cannot be directed by a writ of mandamus to do something which constitutes prohibition.
We understand well.
But second proposition that I'm giving Your Lordships is that in every matter where a writ is sought, or in every religious matter where an intervention is sought against a non-state entity, every such PIL should be relegated to 92, say read with section 9, 15 and section 26 of the CPC. 15 says present the plaint before the lowest competent court. 26 says file a suit by presenting a plaint. And in that plaint, expert evidence along with all issues can be done. The expert can be voir dire. Whether he is an expert or not, that can also be tested. So that second proposition that I'm giving, that the suit is the way that should go. But the last proposition that I'm making, it's a bit bold. But if your lordships would turn to page 12, I am saying as a policy of judicial restraint, this court may take a call,
Well argued,
But what I'm telling is that we are to draw a presumption whether an act is constitutional or not. Now 25 uses the word entitlement. The opposite of entitlement is deprivation. So if something was available to me and I was entitled to it until yesterday, and if it has been denied to me or deprived today, then the legislature should come and explain how the entitlement has been taken. So the proposition that I'm making is that one who interferes and disentitles should prove that his legislation is within the constraint of 25 and 26. But lastly, there can't be any privity or parity with Sabrimala. Last I'm saying is that all this institution, this Waqf institution and temples, all are left to fend for themselves. They are not sponsored or granted because we are a secular nation. We can't fund an institution directly except somewhere laws have been passed or they have been enacted that way. Because all that I'm saying is that it will be a travesty that whilst we can't give them any, that's money, we can't give them any, we won't let them have any, that's freedom. If you can't give them money, at least let them have their freedom. But I'm grateful.
Thank you.
Obliged.
Please see it.
C. Rajendran.
All right, 2 minutes, please. Huh?
Yes, my lord. My definite case is that, my lord. This temple, this was not a Hindu temple. It was a Buddhist pagoda. My lord, the name Shibir is training. Shabarimala is a training center for the Buddhists on the top of the hill. Thus, it became known as Shabarimala. But is the Dalai Lama's palace is also named as Shabarimala. Your Lordship may kindly say, there are 60 to 70% of the Keralites were Buddhists, my lord. Thereafter, the advent of the Vaishnavism and the Shaivism and also Bhakti Prasthanam by the Shankaracharya, all the Buddhists were wiped away from the Kerala. My lord, that is but this was being on the top of the hill. My lord, it remained there. Your lordship can see it, page 3. It was a Buddhist pagoda.
Yes.
My lord, later on, it was converted into a temple. Second page. And the third picture shows it was converted into a Pakka temple by flag posts, etc. My lord. There are two types of temples in Kerala, my lord. Samadhi Pidams and Prana Pradishtas. Prana Pradishtas, the prana of the person who was giving it is transmitted to the idol, and the idol becomes a living person. But the most powerful is the Samadhi Pidams, my lord. That is a contemporary of Lord Ayyappa entered into Samadhi. A picture, your Lord may kindly see, page 6, my lord. His name is Sang Tansin, who entered Samadhi.
Yes, yes.
My lord, his body was mummified there. And in the 2004 earthquake, it came out for. Now that is why we will get the port. Your Lord may kindly see the picture of Ayyappa. This sitting a poster of Ayyappa as well as this Buddhist is same, my lord. This sitting of Ayyappa is known as Pattabhaddhasanam. But my lord, the practitioner is generating heat in his body, and for not losing it, they are sitting either on the skin of lion, deer, etc. Here, Ayyappa is sitting without touching his buttock or anus in the ground, so that the practices generates heat for the awakening of the Kundalini and push it up to the Sahasradhala Padma. Then only the man comes to the stage that I am Brahmasmi. That is another aspect. So my humble submission is, this is a distinct Buddhist temple, and there was big rivalry between Vaishnavis and Shaivis. And in order to coordinate them, a story had been built up that Ayyappa is the son of Shivan as well as the Vishnu, and he has been given a name Harihara Putra. This is the manipulation, sir.
We are not going to this issue, Mr. Rajendra, right now.
Stands on a separate distinct denomination, and the menstruation is not at all a stigmatic, and it is a divine process in Kerala. It is stated that menstruating women are moving gods, walking gods. So your Lordship, my humble submission is the real nature of the temple has not been brought up, and the Mahendran.
All right, thank you.
So my submission is that the right of the devotees of Ayyappa may be kept open for agitating before the Honorable High Court.
Thank you. Thank you, Mr. Rajendra. Yes, madam.
I'm Advocate Usha Nandini, and I had assisted Mr. Gopal Shankaranaran as well as Mr. Jain Mudraj in other two matters. And being a devotee, I had separately filed an intervention application in the main petition and separate review petitions. This is in 901.31, wherein Mr. Chidambaresh has filed a separate written submission, and these submissions are in addition to that. Kindly see, Your Lordship, the present submissions are confined to only question number 3 and 7 in the reference. I am not looking into the other questions. The first one is whether the rights of a religious denomination under Article 26 of the Constitution of India are subject to the other provisions of Part 3 of the Constitution for India, apart from the public order, morality, and faith. And the answer is no. Kindly see, Your Lordship, the framers of the Constitution consciously omitted the word subject to the other provisions of Part 3 in Article 26. And the rights of the individual under Article 25(1) are subject to public order, morality, and public health, as well as to the other provisions of Part 3 of the Constitution. And this necessarily includes Article 26. And at the same time, the rights of a religious denomination or a sect thereof, which may include a group or community, under Article 26 are subject only to public order, morality, and public health, and not to the other provisions of Part 3. Kindly see, Your Lordship, then the diversity of religious practice vis-a-vis religious denomination under Article.
Make out your point that we will read, madam.
No, Your Lordship, only one paragraph.
Not there now. These are all extra burden on us.
Kindly see, Your Lordship, the seventh question. There is a question that whether a person not belonging to religious denomination or religious group can question a practice of that religion. And the answer is also no, Your Lordship. And a person who neither profess or the relevant faith nor participate in the associated practices has no right, whether constitutional or otherwise, to challenge such practices on the ground that they conflict with their own values and beliefs. And, Your Lordship, another point is, Your Lordship, regarding the bill filed in Sabrimala. My submission is, Your Lordship, it's like forum shopping. Because kindly see the statement by
very well. That has been argued in detail.
No, Your Lordship, the thing is that see, all the petitioners, they are from the NCR region only, and that is the only reason they had preferred the writ petition under Article 32 instead of approaching the Kerala High Court under Article 226. And I can say that it's not a public interest litigation, it is a publicity interest litigation only. That point may also be considered. And Your Lordship may, now Your Lordships are poised to deliver an authoritative judgment in Articles 25 and 26. And at the same time, I request Your Lordship to frame some guidelines for considering this kind of public interest litigation, Your Lordship. That's all, Your Lordship.
Thank you. Thank you, madam.
Please, Your Lordship, my Lord, I'm Prachi Vajpayee. I'm appearing for two petitioners, my Lord. There are two review petitions are there. The first one is for the temple, which is Ayyappa temple, which is 5,000 years old and is owned by a family. And following the same rituals as it is in the main temple is there. The another petition which, my Lord, I have filed is for Samastanayar Vanita Samajam, that is a woman wing. So, as far as Your Lordship has framed the questions, and we are here for discussing those questions, my Lord. The first
mic also yourself.
My Lord.
Yes. Yes.
Both the mics with you.
My
Both mics.
Yes.
Use your full voice.
My Lord, the first question Your Lordship has framed, that is regarding the scope of the Article 25, my Lord. My Lord, we know that every freedom and every article of freedom is subject to some conditions, and the Article 25 is not an exception to that. The another question Your Lordship has framed regarding the interplay of the Article 25 and 26. My Lord, there is a saying that my right and freedom to swing my hand ends from where the others' rights and freedom starts. So it should not hurt the others' freedom and right, should not infringe. As far as the Article 26 whether it is a part of, subject to part of other articles in part 3 or not. Well,
Yes, yes, correct.
so we have to, as your lordship has held in many judgments, that we have to adopt a harmonious construction of interpretation, and every article and intent of the constitutional framers has to be given a meaning, because if one we give importance to the one article and the other is subserved, then we will not be, rather we will be denying the intention of the constitutional framers. As far as the question regarding the morality is concerned, my lord, the constitutional morality is nowhere mentioned in the plain reading of my understanding. Nowhere it is mentioned in the constitution, and framers could very well use that word constitutional morality, but they have not intentionally. So in that article, the word morality is used, and we should take it as a morality simpliciter in the context of that article, which is focusing on the religion, my lord. So we have to see the morality from the perspective of the religion, and even the judicial interference is also only should be unless until it is so much required by your lordship, and then unless it is so much against the humanity, which cannot be which cannot be a person cannot which cannot be avoided, my lord. I'm sorry. And as far as the word section is mentioned in the Article 25B, my lord, it is we have to see from the perspective of the Article 17, which is clearly it is regarding the excluded class, which were not allowed to enter, and the temple after the independence, the temple were the entry was given to the excluded class. My lord, the persons who are not belonging to the denomination, they should not challenge the rules, as we know that our rights only limits to that others rights should not get infringed. So individual right is my specific right, which ends to the practice, what practice I follow. Well, the moment I join the institution, it should be subject to the rules framed by the denomination or the institution.
Thank you. Thank you.
Madam, we didn't get your name. Madam, can you tell, we didn't get your name, madam.
I am Atulesh Kumar, my lord.
Madam.
I'm Prachi Vajpayee, my lord.
Oh, thank you.
My name is in the list.
Oh, thank you.
I am appearing for Akhil Bharatiya Sant Samiti, my lord. IN number 98855 of 2026, my lord. I am Atulesh Kumar, my lord. My short submission, my lord, I will not take much, more than 2-3 minutes, my lord. My lord, submission on the issue of scope and extent of the judicial review with regard to the religious practice as referred to in Article 25 of the Constitution of India, that is reference number 5, my lord. To substantiate my point, my lord, I would like to give 1 or 2 examples, my lord. So for religious practices as concerned, my lord, where I have given the example, my lord, of 12 Jyotirlinga, my lord, in which specifically one Mahakala temple where Bhasmarti is performed. All 12 temples of all Jyotirlinga is the manifestation of Lord Shiva. But so far as Kaleshwar temple is that, my lord, there Bhasmarti is performed. That Bhasmarti is not performed with other Shiva temple. That is the religious practice followed, my lord. So far other example are concerned, my lord, 51 Shakti Pithas are there. But Kali temple in Calcutta and my lord, one more temple in Kamakhya temple, the religious practice are totally different. My lord, there are 3 types of temple I have mentioned in my 4 pages note, my lord. Private temple, that is Griya or home temple, social temple, and Tantra temple. I will skip, my lord. I will skip, my lord. And so far as my submission on the Sabarimala my temple is concerned, my lord, this restriction between 10 to 50 is not violative of Article 14 of the Constitution. My submission is, my lord, because there is no absolute restriction, my lord. is prior to 10 and then post 50 it is allowed. So there is no restriction, absolute restriction. Therefore, we cannot say this is violation of Article 14 of the Constitution, my lord. And I can give the example of, my lord, Article 19, what freedom of speech and expression subject to Article 92. My lord, the essential religious practice doctrine has developed by the court in Surur Mat case, my lord. In Sabrimala, my lord, in 5 judges bench, the gender equality has taken precedence over the traditional religious practice. My submission is this, my lord, Article 40, Article 25 and 26, both are fundamental right. We cannot give precedence to one article, another article. 25 is subject to public order, health, morality, and other parts of part 3 fundamental right, whilst 26 is, my lord, subject to public order, health, and morality. In my submission is this, my lord, one article, both are fundamental right. Well, our constitution forefather has given in this, my lord, we cannot take one article, cannot take precedence of other, my lord. That is my submission, my lord. And one more point. There can be resolving of this when conflict arises. Sometimes overlapping individual rights are overlap with the denominational right. In that case, my lord, balancing effort should be taken and harmonious construction should be taken to balance that. My lord, my submission is the courts are not expert in theology. Therefore, the courts should not determine the religious practice. That is one submission, my lord. Belief and faith have to be existed in India since time immemorial. It's not that after constitution it is there, my lord, but only the constitution has legally enforced there. And it was first in the preamble and then in Article 25 and then in 26, my lord. In Venkatramana Deuri, my lord, these article has read together to make a balance, my lord. And in Sirur Mat case, my lord, it is held that a state can regulate the secular, economic, and administrative activities of the religious institution, while it cannot interfere with the essential core of the religious practices as an internal management, my lord. My lord, rest of the submission made by the learned solicitor, my lord, I accept, my lord.
You want to ask? Yes, what's your good name?
Gauri Subramaniam.
Are you there in the list? Oh, all right, start.
Your Lordships, I'm appearing for an intervener. This is the Bombay Parsi Panchayat. And Your Lordships, you know, all our senior counsels have argued these the matters of law and historical context with great erudition, so I'm not repeating any of it. I have prepared a very short note. At the end of that note, I'm not going through the note at all, but at the end of the note, I've also prepared a flow chart, which I'm hoping would be of some assistance to your Lordships. It traces how a state action can be, how you can actually analyze a state action with regard to denominational rights and religious freedom. I only wish to make 3 very short points. The first is, your Lordship, specifically in the context of the Parsi matters before you, empathy is very important. There is an emotional cost being paid in this particular set of circumstances, but it cannot blur the constitutional boundary between religion and regulation and religious autonomy. Secondly, what may appear as a narrow accommodation today risks becoming a template for incremental constitutional erosion in the future. And thirdly, if individual or even a group of individuals, as in this case and in many others, if an individual's hardship becomes the governing metric, then every denominational boundary becomes negotiable, and then Article 26 risks being reduced to just a case-by-case exception. Lordships, my flowchart is right at the back. Right.
Thank you.
You are very precise.
Very good. Exactly, directly on the point. Yes, please. Yes.
Honorable Chief Justice and the companion.
You need to address us.
Yes.
Now you know who you are.
My humble submission is regarding the 3 aspects.
Yes.
One is this constitutes the morality, constitutional morality and societal morality. Societal morality. Societal morality can be there, but there cannot be constitutional morality like that when we interpret the constitutional morality, it will lead to many multiplicity of litigations like that on the basis of principle of morality. Second thing, that any sort of judge of the thing which is called the denomination. The denomination is particular aspect of one religion which is specific to one state. It is not comprising of the entire state. So connoting religious denomination for a particular state is not an entirety to maintain that the Hindu religion is having an overall aspect of that. Third thing, my Lordship, that is related to subject to public order, health and morality. Now, I just suggestive in nature that there has to be a non-discrimination is there subject to non-discrimination and antithetical to the rules which is mentioned, articles mentioned in 14, 15, 19 and 21. That should be there, the interpretation of the review. And that is my humble submission. Thanks for patient listening, my lordship. Thank you.
Please. My lords, my apologies. I understand your lordships have reached saturation point and looking forward for them to start. I will confine my submissions to just one limited aspect, my lords.
There
which
is
is the
throw bouncer or hit the bouncer. That's all.
Very well, my lords. I'm appearing in IA number 99340. I'm confining my submissions on just one aspect, which is the subjection of Article 26 to Article 25.2. Now, my lords, in my submission, Article 25.2 is inapplicable to 26. And I say so for the following reasons, my lords. Lords, at the outset, if one were to compare the language of the two articles as also the constitutional debates that have happened, it is evident that the framers wanted to vest superior rights in religious denominations. They wanted to treat them separately. And this is so because religious denominations historically have been a closed set, private, exclusive in nature, and nobody could claim as a matter of right their membership should be extended to them. Now, my lords, more importantly, the language in which 26 and 25 are couched, if one was to juxtapose the two, it is evident they contain express and implicit indicators that 26 was supposed to be immune from 25.2. And I say so for the following reasons, my lords. Firstly, your lordships have noted that there is a subject to clause in 25.1, which subjects it to other parts of part 3. Now, 25.1 will obviously be subject to 26 as well. Similarly, my lords, the subject to clause is absent, is conspicuous by its absence in 26. And your lordships have noted that. Your lordships have also seen the subcommittee report on fundamental rights. The original formulation contained that clause, that they were to be, the rights of religious denominations were to be read consistently with the provisions of the chapter. But in the subsequent iterations, that phrase was dropped. And for good reason, my lords, because the framers had the foresight to not frame 26 in a manner which would lead to a contradiction in terms. It can't be that 25.1 is subject to 26, but 26 is also subject to 25. That could not have been the scenario, my lords. Thirdly, my lords, 25.2 begins with the phrase, nothing in this article, so it is evident that it is confined to operation. The regulatory powers of the state are confined to 25.1 itself. Fourthly, and now I draw your lordship's attention to the latter part of 25.2b. It says throwing open of Hindu religious institutions of public character. Now, as I alluded to earlier, there is no public character. Historically, they've been a closed, the religious denominations have been a closed set. And most importantly, my lords, a reference to Hindu religious institutions by virtue of explanation 2 covers Sikh, Jain, and Buddhist religious institutions as well. Now, please see the consequence of applying 25.2b to 26. Hindu, Sikh, Jain, Buddhist religious denominations get covered, but Islamic, Zoroastrian, Christian, etc. religious denominations are excluded, so that it has a discriminatory impact on other religious denominations.
There is no exclusion as such.
That's right.
In other religions, there is no exclusion.
No, but the
specific to Hindu religion. That is why the constitution framers were conscious of the fact that Hindu temples could not exclude, particularly the depressed classes, as they were called earlier.
So I'm not suggesting for a moment that 17, 23, 24 will also not apply. Those are the only caveats.
See, this is something depressed classes, you can say depressed caste. Such a thing, caste system is not there in other religions. So why should they write about other religions in the article?
Your Ladyship, that may not be true.
They are conscious of the reality of the Hindu society.
That may not be true. Even in Islam, there have been divisions within different sects of Islam. But without that, I'm confining my submissions to first principles.
It's only applicable.
I'm confining my submissions to first principles. If your lordships were to read explanation 2 in the text, in the language in which it is couched, it is confined to Sikh, Buddhist, and Jain religious institutions. So if it were to apply to 26, it would lead to a discriminatory application of that provision. And in my respectful submission, no such interpretation should be given to 25.2b, my lords.
Thank you.
My lords, just 2 more points, my lords. And my lords,
quickly, please.
So, yes, my lords. In fact, I'll skip the second one, just the last point, and I'm taking sustenance from what Justice Bagchi had said the other day, that 26 is a special provision. It is carved out from 25.2. I'm pressing into service the doctrine of generalia specialibus non derogant. Special excludes the general, and in my respectful submission, it will not apply to 26 laws. Lords, I'm very grateful for the opportunity.
Thank you.
With your lordship's permission.
करेंगे आपसे और उससे वो बैठे हैं हमारे बॉम्बे वाले साहब, दोनों से बाद में निपटूंगा। Because we are not sure whether you want to argue this side or this side. You are definitely arguing this side. And then wait for 5 minutes. Yes, yes.
My lord, the prism through which, my lords, one looks at, my lord, 25 and 26. If that first expression in Article 25 would hold the key, is the first submission, and that is the right to conscience. Because if we understand, my lord, the right to conscience, my lords, within its operational sphere, then probably 25-26 represents the layered form of that right to conscience, including even the sect. So, my lords, it is in that context, my lords, that I open it. The freedom of conscience denotes, my lords, I'm coming straight to 1A, my lords, having explained, my lords, the first segment of it. The freedom of conscience denotes the right to lead a life as guided by the thought process of the inner self. And, my lords, it need not be always be rational. The canons of rationality may not be applicable. And that is why it takes the form of beliefs and the external manifestations of those conscience, or the rituals, performances, etc. When two or more individuals, my lord, share that common conscience, then that evolves as the conscience of either a sect, cult, group, or a religious community. So that takes me to 1D, my lords. 1C, sorry. The freedom of conscience of an individual thus encompasses the freedom to follow the personal conscience in his personal space. Now, that personal space is very important. 2, the freedom to be distinct and to dissent even in a collective forum. That is the freedom to distinct and dissent, my lords, even in a collective forum, including, my lords, probably a religion. The third is the freedom to lead a life governed by the uniform or the shared conscience of the collective forum as its member. So that takes us, my lords, to the concept that as far as religion is concerned, then the worship, beliefs, observances, I'm coming straight to 2, my lords. I need not trouble your lordships with 1D. Includes now the rituals, worships, etc., which are all, my lords, the external manifestations of that conscience, would necessarily come as a package, including the forbearance, the restraints, the injunctions associated with it. Then, my lords, Article 25 by itself determines the contours of application of the right of equality. Because the general notions of equality is there, my lords, Article 14, 15, etc. It gets a specific form in Article 16. And similarly, it gets a specific form in Article 25. So you look at Article 14 through the prism of Article 25 rather than the vice versa. Then, my lords, if so, in the context of Article 25, the right of equality does not take within its fold the right to profess, practice, and propagate religion in variance from the manner in which it is professed by either the religion or the sect. And that is the key to understanding that sect or denomination, even in the context of 25. Article 15.2, 15.4, and 16.5, my lords, are pointers to this. Because, my lords, 15.2, it actually avoids, it does not provide an unbridled access to the temple. While, my lords, the framers were very sure of what other public place should that access, unbridled access, be provided to. There was no such restriction in 15.2. Similarly, my lords, Article 16.5 as a pointer that, my lords, as far as the appointment of any office is concerned, for example, my lord, Alcheka, etc., that is recognized by 16.5 itself. And as far as the belief, which is the outcome of conscience, need not, my lords, appeal to rationality. Then, my lords, I come to even a single temple could constitute a class by itself. That depends on the form of the deity and the variable form of the deity. Chidambaram, we have an example where, my lord, the idol, my lord, has no shape. I just leave it at that, not quoting, my lord, further examples. Then, my lords, as far as the seventh proposition is concerned, at page 3, my lords. Article 25, my lords, when an individual, Article 25 as well as 26, my lords, is linked through this umbilical cord of conscience. Because unless, my lord, the right to profess, propagate, and practice that religion is conferred, probably at some point of time, the sect or the denomination may lose its distinctive identity and it may be rendered to oblivion. So that is, my lord, that link. Because what you practice in the 26 is nothing else but the conscience of that sect and its external manifestations.
Then Article 25 will apply to Article 26.
Yes, my lords. Yes, Article 25, my lords, and Article 25 would be
come along with the,
yes, my lord.
with the restriction imposed under 25(1) and 25(2).
My lord, there it will be a balanced approach.
Either you go this way or that way. You can't say take a bite here, bite there.
No, I'm not saying that, my lords. I'm not stretching it to that extent.
You say that the rights and flows under Article 25 to Article 26.
Right.
Then liability also will come.
My lord, naturally, that liability under 25(2)(b), my lords, to the extent 25(2)(b) is there my answer would be only, it would serve as a balancing act, my lords. It would be a balancing act, not one above the other. I'm not placing 26(b) above, my lords, 25, because it complements each other is my submission.
Anything else you guess? Anything?
My lords, I've given, my lords, at para 10,
Yes, yes.
the judicial review, the counters of judicial review. My lords, I leave it at that. The last point, your lordships may just note, para 13, because Mahendran's judgment, my lords, the evidence was taken. Can, my lords, a subsequent repetition without the factual basis unsettle a judgment which has become final is something which your lordships consider. Obliged, my lords.
Thank you. Thank you, sir. Thank you. First, that lady should ask.
Please, Lordship. Lordship, may I seek indulgence to circulate my
Yes,
4,
take
5
two mics.
page submissions?
Take 2 mics with full voice.
Please, Lordship.
Yes, please. Go ahead.
Lordship, this case is not about gender equality in the abstract, but about the limits of judicial oversight over religious autonomy under Article 25 and 26. In our submissions, that majority judgment in Sabrimala erroneously replaced the essential religious practice with a modern rationality test which exceeds the correct jurisdiction, Lordship. With this backdrop, Lordship, kindly come to page 2 of my submission that courts cannot judge rationality of religious faith. The scope of judicial review does not extend to evaluating the reasonableness, rationality of a religious belief or practice. This court inquiry must cease once it is satisfied that belief is genuine and not a pretense. This honorable court in 5 judges judgment, M. Siddiqui, Ramjan Bhumi, this paragraph is quoted. Now, Lordship, kindly come to page 5 straightway, para 5. This is harmony of rights. Lordship, no right is superior to another. So this is majority judgment. Treats Article 14 as an overriding constitutional norm capable of defeating the protection afforded by Article 25 and 26. Whenever the religious practice involves a distinction, this reading is irreconcilable with the 9 judges constitution bench in Ahmedabad, St. Xavier College Society, so-and-so. Para 75 is quoted here in below, Lordship. So now my submission would be, Lordship, this 9-judge bench must accordingly restore the original constitution equilibrium. This is my submission, Lordship.
Thank you, Bharti. Thank you. Thank you. Thank you very much.
Grateful, Lord.
Any other young lady interested to argue? Please come forward. Anyone? Otherwise, yes, you start.
Yes, my lord. No, I'm appearing with one of the intervener. My application.
If any woman lawyer, any young lady lawyer wants to argue, please come forward. We will accommodate. You start meanwhile. Yes.
My application number is 88066 of 2026.
My lord, I am proposing a 6 propositions, my lord. The first one, proposition 1 is reconceptualization of the religious denomination, my lord. So it is the devotee, if he wants to pray a deity, he will have some devotional makeup so that he will think about the deity and he will pray for him. So the moment when he does that, a group of that makeup, where we can say that they consider them as independent spiritual fraternity, where I have dealt with that, my lord, in my written submissions as well. And next aspect is, if in case, if this honorable court feels that essential religious practice is necessary and required, they should follow a certain aspects, which I call it as a spiritual physics, which are called as the agamic tenets or any tantric way of worship. So these things has to be tested, my lord. And the another aspect is the bar against institutional syncretism. This is one which I want to highlight, my lord. So thing is, under Article 25, an individual is having a right to practice their religion, and they can practice multiple religions, and even they can mix up and they can do that. But that mix up should not be brought into this denomination. So the moment you enter into the temple, you have to adhere to those principles and practices with respect to the temple. So, and another aspect relating to denomination, I'll come back again, my lord. When we consider this Shaivism, Vaishnavism, all these temples as denominations, so the moment in each temple, Krishna is considered as Radha Krishna and as well as Rukmini Krishna. So all these temples, they fall under the category of section thereof. So simply where we cannot say that, see, Hinduism is a denomination and where we should not give a static test. Even, my lord, in my written submissions, which that I have handed it over, where I have given a definition.
That we will see, please finish, because you have not asked for any time, we have adjusted you.
Yes, my lord. And next thing is proposition number 4. I'm coming quickly, I'm wrapping up now. So what is the state's power under 25.2? So under 25.2, according to me, it is only with respect to financial administration and as well as other secular aspects. It means earlier there are certain temples which were not managed by anybody. So in those circumstances, the state has stepped in and it has taken over as a custodian. It doesn't mean that the state owns the temple. So what state can do? State can legislate it and state can take care of the temple.
All right, next.
So next point is, I have proposed one test with respect to the morality. Morality, no one has dealt with this. No, my lord.
Next.
The thing is, what is morality? This is what I just wanted to highlight, my lord. So if you see from the lens of 25, there are 2 aspects are there. One is the morality with respect to the individual towards the religion and as well as towards the public. So with respect to from his activities, he cannot create any kind of distress towards the society. And another one is 25 with respect to the impersonification. There are certain godheads are there. There are a few more clerics are there, which they say that I am the incarnation of God. So they should not bring disgrace to that specific denomination. And to that extent, where the Maharaja libel case is there, my lord, where I have given it my written submissions, where they have dealt, a specific line is there. What is not correct in theology, it is not right in morality.
All right, thank you.
So, and one more aspect, my lord. And with respect to 26, my lord, there is one judgment called Sheshayengar. What they have held is, a denomination, they can practice, they can conduct the practice at a private area, but it should not disturb the neighbors. This is again 1880 judgment, my lord. And next aspect is, as your lordships has pointed out, if there is any threat or harm, so do we have a jurisdiction? Yes, my lord. As a parents party, the state can step in. This is one way of looking at it. Parents party jurisdiction where they can step in and they can curb those practices.
Thank you.
And my written submissions, my lord, where I have given it, I just give the page number, my lord. It is volume 1.2, 714 to 746, my lord.
Thank you.
Thank you.
Lord, I appear.
First tell you,
Yes, my lord. Just 3 points I'll conclude with that, my lord. I appear in IN 91810. Yes.
you please tell us, have you given your name in the list?
My lord?
Have you given your name earlier?
My lord, yes, my lord, I had given, my lord, my lord, my name is Arvind Srivatsa. My name is there in the original list also as serial number 45. My lord, I appear in IA 91810 of 26. My written submissions are in volume 1.1, page number, my lord, 848.
Yeah.
My lord, I'll not repeat what has already been argued. Just three propositions I'll place, my lord. First submission, my lord, is on the scope of Article 25.1. There are three parts to 25.1 which your lords have already heard. One is on, my lord's conscience. The other is profess. These two are internal absolute rights. My lord, on propagate and practice, my lord, that will be subject to the restrictions of the language in 25 itself. 26, on the other hand, my lord, contains no restriction on subject to part 3 rights. Therefore, if, my lord, there is an apparent conflict between 25.1 and 26, 25.1 must yield and 26 will play over 25, my lord. And 26, my lord, is subject only to the restrictions of, my lord's, morality, public order and health that are available in the language of the statute itself. Therefore, my lords, insofar as 25.1 and 26, my humble submission is they are different constitutional spheres, and my lord, that they are different constitutional functions. One is on right of individual, the other is on, my lord, the management by the institution itself. My lord, and the submissions on, my lords, Ratilal's case and Shirur Mat, I'll not repeat. The only last point that I'll make is on Devaru. My lord, submissions were made on Devaru. In fact, questions were put by this honorable bench also. Lord, my endeavor is to say that Devaru should be read in the context of Article 17 alone. My lord, the concluding paragraph at page 248 of volume 5, my lord, this honorable court was pleased to already note it, which is Article 26b must be read subject to 25.2b. My lord, this, my endeavor is to say, kindly read this in the context of 17 alone, because what the court was dealing with on the facts of that case was caste bias exclusion of entry into the temple, not anything else. My lord, therefore, the finding that it is subject, my lord, it is beyond 26 itself. My lords, I would request a lordship to kindly reconsider and only restrict to 17. Not only one other fact on, my lords, statutes that are there, two statutes, which is the Tamil Nadu HRNC, the Hindu Religious Endowments Act, and the Karnataka Act in sections 107 and 69. Both of these provisions, my lord, specifically refer to that nothing in the act will, my lords, nothing in this act shall, save as otherwise provided for in 25.2, be deemed to confer any power or impose any duty in contravention of rights conferred to religious denominations under 26. So this 26 being on a higher pedestal is recognized in other two statutes. I just wanted to place it before. I'm grateful, my lords.
Thank you. Thank
Grateful.
you. Thank you very much.
May it please, my lords. I'll just take 2 minutes, my lords. My submissions, I appear in IA 84798. My submissions are on record.
What's your name?
Akshay Nagarajan, my lords. My name is not there in this list, but I have given my submissions around record.
First, let them finish, those who are earlier. What's your good name?
Sanand Ramakrishnan.
Please, Sanad, you are there.
Yes.
Please argue.
I appear in item 901.29. I appear in review petition diary number 9135 for the Kerala Brahmana Sabha.
Argue that we will find out whom you are representing. Don't worry.
No, my lords, I will be only briefly touching upon issues number 2 and 7. Issue number 2, of course, relates to interplay between 25 and 26, and 7 relates to whether a person not belonging to the denomination can question. That's coming to interplay. Both articles 25 and 26 are subject to public order, health, and morality. However, 25 is further subject to other rights in part 3, as also including 26. Article 26, on the other hand, does not have such a limitation. Typically, these rights are conferred on non-state actors. In case of infringement of this right by legislation or state action, a constitutional court can be enforced directly, and there is no difficulty. It can be the grievance can be redressed. Difficulty arises in cases where there is no state action or legislation, and the individual asserts Article 25 rights and alleges violation by denomination, and the denomination in turn asserts its own fundamental rights under 26, denying the allegation. So there is a dispute between two non-state actors, each asserting fundamental rights. In this situation, Article 25 can be said to be subordinate to Article 26, as Article 25 is subject to other Article 3 rights, including 26. This scenario with non-state actors asserting competing fundamental rights comes within the classic scenario of horizontal enforcement of fundamental rights. In Puttuswamy, this court has held that privacy is both a civil right and a constitutional right. If there is a peeping Tom neighbor, I can approach the civil court, get an injunction. And if the peeping Tom is the state itself, then I can approach the constitutional court and get my right protected. Therefore, the manner in which I enforce my right, whether it is civil or constitutional, is well settled. In Kaushal Kishore, the court considered whether fundamental right under 19 and 21 can be horizontally enforced. Earlier position was that it cannot be. However, the majority, having regard to the evolution of constitutional law in various other jurisdictions, held that some fundamental rights are horizontally enforceable. The majority judgment also contains a chart at para 73. Article 25 does not figure in that chart. It is conspicuous by its absence. So in a dispute between two non-state actors, there is no scope for an individual to use his or her right under 25 against religious determination or section thereof. The dissent in Kaushal Kishore holds that only 21 and habeas corpus rights and no other fundamental rights are capable of. The reasoning is that necessarily disputed questions of fact arises in such determination. So this dissent that disputed questions of fact cannot be adjudicated in 32 and 226 assumes great significance when an Art 25 right is pitted against a denominational right. The individual would argue that the practice against the practice, and the denomination would assert long practice. Hence, without getting into the correctness of Kaushal Kishore or the dissent in that case, it can be safely concluded that an individual cannot horizontally enforce a fundamental right under Article 25 against the community or the religious denomination thereof through a constitutional court. If this is the case, the bodies, organizations of the nature referred to in question 7 cannot have any enforceable Article 25 claim before a constitutional court. My written submissions have been placed, settled by P.B. Krishnan, senior advocate.
Thank you, Mr. Ramakrishnan. Thank you. Thank you.
My lords.
We'll hear you. Don't worry. What's your good name?
My lords, Rajneesh Kumar Jha.
Rajneesh Kumar Jha. Yes, Mr. Jha. Yes.
My lord.
2 minutes, please.
My lord, have framed
Straight
a
to the point.
substantive question of law on 16th February 2026. My lord, the first question: what is the scope and ambit of right of freedom of religion under Article 25 of the Constitution of India? My lord, as regards Article 25 of the Constitution, which guarantees to every person freedom of conscience and right to freely profess, practice, and propagate any religion, this right is not confined to citizens alone, but covers all persons residing in India. But the right to freedom of religion guaranteed by this article is subject to restrictions, which may be imposed by the state on the grounds of public order, morality, and health. My lord, as regards the second question, what my lord have framed, what is the interplay between the rights of persons under Article 25 of the Constitution of India and rights of the religious denomination under Article 26 of the Constitution of India? My lord, while the Article 25 subclause 1 of the Constitution protects the religious freedom of an individual, Article 26b deals with the collective rights of the religious denomination. While an individual can practice only such rights as are well established and recognized by the community as integral part of his religion, a religious denomination enjoys the independence of determining the rites and ceremonies which shall be essential according to the tenets of that denomination. That while Article 25(1) grants freedom of conscience and the right to profess, practice, and propagate religion, Article 26 can be said to be complementary to it and provides for every religious denomination or any section thereof to exercise the right mentioned therein. This is because Article 26 does not deal with the right of an individual, but is confined to religious denomination. Article 26 refers to a denomination to any religion, whether they belong to majority or minority religion. Just because Article 25 refers to all persons, whether they belong to a majority or minority religion, Article 26 gives the right to majority religious denomination as well as to minority religious denomination to exercise the rights contained therein. My lord, may permit me to read the judgment Sirur Mat, my lord.
No, there is no need to. You
My lord,
point out the paragraph.
The third point, the third question, my lord, whether the rights of religious denomination under Article 26 of the Constitution of India are India are subject to other provisions of Part 3 of the Constitution of India,
paragraph, please.
apart from the public order, morality, and health. My lord, that while Article 25 extends to all persons, Article 26 is confined to religious denominations. Hence, there is no anomaly in the fact that while the rights under both the Articles 25 and 26 are subject to public order, morality, and health, Article 25 is also subject to other provisions of Part 3. My lord, while Article 26 is not. My lord. Question fourth was, well, what is the scope and extent of the word morality under Article 25 and 26 of the Constitution of India, and whether it is meant to include constitutional morality? My lord, that the concept of constitutional morality refers to moral values as enshrined under the Constitution, necessary to answer the correct meaning of the Constitution and the object behind it. Constitutional morality is, in secular country like ours, gives freedom to practice one's own faith based on the tenets, custom, or usage of the concerned religion. My lord, as regards fifth question,
So
what is
please
the
don't read, just
scope?
sum up your argument, you have
Yes,
prepared
yes,
it
my
and
lord.
just tell us what is
My
it
lord,
about.
what question my lord has framed, I am answering all those questions, my lord.
You just answer it, but don't read it and then tell us now.
My lord, I will.
If you want us to read, we'll read it. No
What is the scope and extent of judicial review, my lord? I have already answered, my lord. What is the meaning of expression of section of Hindu occurring in Article 25(2)(b) of the Constitution of India, my lord? In Article 25(2)(b) of the Constitution of India, the explanation 2 expands the connotation of the word Hindu to include Sikhs, Jains, or Buddhists. But this expansion will not apply to any other provision of the Constitution. Hindu is a comprehensive expression, as the religion itself is, giving the widest freedom to people of all hues, opinions, philosophies, and beliefs to come within its fold. This means that even though the religions of Sikhs, Jains, Buddhists arose out of descent from Hindu religion, for the generality of purposes, those religions should be considered to be different from the Hindu religion. But for the purposes of Article 25(2)(b), they should be considered as part of Hindu religion, and consequently their religious institutions of a public character should be thrown open to all sections of the Hindus instead of being confined to members of their own sects or denominations. My lord, last questions, what my lords have framed, whether a person not belonging to a religious denomination or religious
Available before us.
My lord.
Why are you reading it?
No, my lord, I have prepared it, my lord. I'm sorry.
Read it, we read it.
That we will read.
Read the questions only, give your answers.
My lord, the religious, as regards the religious denominations, my lord, last question was whether a person not belonging to a religious denomination or religious group can question a practice of that religious denomination or religious group by filing a PIL. My lord, the answer is no to my.
All right, thank you very much, Mr. Jha. Yes, young man. Yes, yes.
Sorry, my lords, I didn't mean to jump the queue. I couldn't give my name in the original list, but my written submissions are on record. They're at volume
What's
1.
your good name?
Akshay Nagarajan.
Huh.
My written submissions are on record at volume 1.2 at page 379. My lords have it. My lords may read it. I supplement Mr. Vaidyanathan, who had appeared in my intervention application. It is the Hindu Dharma Acharya Sabha. They are a conglomeration of 133 sampradayas. They represent Adinams. They represent the Kabir Panthis, the Nagas, and just the diverse conglomerations. My lord, I just have 2 points on the definition of a religious denomination. A lot of learned senior advocates have made submissions. An interpretation was given by learned senior advocate Mr. Vaidyanathan that it should be a sampradaya. Learned senior Dr. Dhawan had said that it should be considered institution specific, which means that any institution which is a religious foundation should be entitled to 26 rights. Learned senior advocate Mr. Deepak had said that it should be a religious association as traceable to Article 19. My lords, in my only point that I would like to canvass is how a religious denomination should not be defined. Over the course of time, my lords, a certain exclusivity and rigidity has been applied in the definition of religious denomination. I will illustrate this point with just one judgment. That is the Adi Visheshwar Kashi Vishwanath Temple versus State of UP. It has not been read. I don't intend to read it. I'll just make a small point on it. A claim was made by the followers of the Shaivite order saying that the law taking over the Kashi Vishwanath Temple is violative of Article 26. A question was put whether the followers of Lord Shiva are a Shaivite religious denomination. My lords have been told the threefold test: common organization, spiritual faith, and designated by distinctive name. Here, my lords, peculiarly, the followers of Lord Shiva had lost, this denominational temple had lost on Article 26 on the reasoning that every Hindu believes in Lord Shiva. Therefore, what is so exclusive to you? That way, my lords, in my respectful submission, no Hindu religious group will be entitled to denominational rights. Every Hindu anyway follows every other god in the pantheon of gods. There is no exclusivity to Lord Ganesha. There is no exclusivity to Lord Vishnu. Similarly, my lords, this had happened in the Guruvayur temple judgment also.
So, the same faith, same practice, there can be multiple denominations.
To multiple denominations, my lord. In my respectful submission, to ask a religious denomination to show us how exclusive you are may not be consistent with the manner in which fundamental rights have been interpreted in our constitution. Now, my lords, in my humble submission, I think that kind of exclusivity has been imparted in the Sabarimala judgment also only because they lost denominational status because everyone is allowed in the temple. Hindus, Christians, Muslims, everyone. My lords, that in my respectful submission would be unique to that temple. That everyone is allowed is something to be preserved. Therefore, my lords, a submission was also made that the judgment in SP Mittal denying the followers of Aurobindo denominational status should be overruled. My lords, I would respectfully adopt that view.
Thank you.
I would also respectfully request my lords to revisit Adi Visheshwar Kashi Vishwanath Temple, 1997, 4 SCC 606. That,
Is the citation?
my lords, it is 1997, 6 SCC 406.
606.
And my lord, similarly, the followers of Lord Krishna in the Guruvayur temple case, they were also denied denominational status because anyway, every Hindu believes in Lord Krishna. What is so unique about this? That may not be the correct test, my lords. And I'll just make one final point and I leave it at that. My lords, a lot has been said on the interplay of Article 26 2B, second part, and Article 25. I just want to make a submission on the interplay between Article 25 2A and Article 26. In my respectful submission, my lords, a law throwing open a Hindu temple of a public character may also govern a religious denomination. It may. Venkatamana Devuru holds the field. My lords will have to take a view. Insofar as Article 25 2A is concerned, there is no textual justification to regulate a secular, financial, economic aspect of a religious denomination by a law. In other words, a law made under Article 25 2A can never govern Article 26 institutions. That is because Article 26C and D already deal with secular aspects.
Why do you say that?
He doesn't say anything about the problem here is everybody trying to think about denomination only into 25. It only speaks about 25 one persons.
But
Yes. Incidentally, institution will come, denomination will come, B will come, other will come. That's not the objective of the constitution. The problem is our mind is fixated on this and we're trying to...
No, my lords, the only thing that there are some state laws that pass...
we understand.
I only admit the submission is that 25 2A cannot be made applicable to a 26 institution.
One example, suppose there is a temple, they want to have an annual festival, like they have the annual car festival.
The car festival, Tere.
Chariot or whatever. You can't block all the roads around the temple. If you start, that is, you see, that
Public
is
order, my lord.
that is one is public order. That has nothing to do with the religious activity. You do your religious activity, but not by blocking all the roads.
Yes.
The state can always step in.
The state can, my lords, the state can step in to regulate.
Exclusive or you.
I'm only... I'm sorry.
Any activity which is not religious in nature, that is the autonomy which is given under Article 26B to that, they can decide what is that religious affair or religious practice.
I'm so grateful.
The court cannot sit in judgment over it. That
Yes.
is the right which is created under Article 26B. Suppose they say we have a particular way of worship in this temple, Suprabhata, etc., etc., etc. That is the autonomy which is given in the manner of worship.
Yes, my lady.
Court cannot sit in judgment and say, no, this cannot be done. That is the idea of Article 26B.
Yes, my lady.
While exercising that, if you are going to public order already is there, apart
Yes.
from that, if a secular activity is also being affected, then the state can step in. There has to be a balance.
My limited submission is only this, that secular activity can be taken care of under Article 26D, because it is only property rights of a denomination.
No, we understood.
I'm grateful, my lord.
Dr. Vivek, 5 minutes. Only 5 minutes. No paper. Don't open. You just argue straight.
You can't block all the city roads and all that.
Lordship, Indian Constitution is not an inert document. It is a living organism, and it takes its effect and the meaning how the Honorable Constitutional Court of this land interprets it. Religious freedom affects every common man, and this common man does not know the complex principles of the law. This is what our Constitution makers drafted the Article 25 and 26. In Article 25, the term religion, and in Article 26, the term religious denomination or any section thereof, these are totally three terms, have the different meanings. First, I will say that what will be the religion? There are four types of the religion. First, the religions which are originated in India and have also the denominations in the foreign or any section thereof in the foreign also, like the Hinduism, Sikhism, Jainism, or the Buddhism. Second, the religions which originated in the foreign land and have also their denominations or any section thereof in India also, like as the Christianity or the Islam. Third, the religions which disappeared, that is the religion without followers. Ancient Egyptian religion, Mitharim, there are some religions which in the Isa 1 to 4th century disappeared. Today they are not existed. But even tomorrow, if any individual started to practice them, then he will get the freedom under Article 25(1). And if a group of followers started to profess that, then he will get the freedom under Article 26. Now the fourth type is, in future, there may be a new religion also, and the same case in that also, for the individual also and for the followers also. Now, Lordship, I will say in the short, what is the religious denomination? Religious denomination means a subgroup within a broader religion. We know in Hinduism, like the Shaktis, Vaishnavism, etc. In Christianity, the Catholics, the Baptist, etc. And in the Jainism, the Digambar and Shwetambar, and in Islam, Shia, Sunni, etc. Now, our constitution makers did not provide any definition or test of religion or religious denomination. Why? It has three regions. First region, religion is not limited to borders. It has international feature and international presence. We cannot say if the followers of a particular faith are not constituting the religious denomination and the followers of a particular faith constituting a religious denomination. For example, Islam and Christianity originated in foreign. How can we apply any test to a foreign originated thing for its existence? It is also. Second, constitution makers knew that the Hindu religion is the compilation of various religious denominations or any sections thereof. There are various gods, various goddesses, various customs, various traditions, various temples, but all are part of Hindu religion. Third, our constitution makers also knew that in future some atheists may try to destroy and spoil the custom and traditions of any religion. Now, I will say one thing more, like the Hindu go to the Kailash Mansarovar Yatra, because the religion cannot be confined to the borders. It has international feature and international presence. It is the important thing to explain the Article 25 and 26. Now, Lordship, the religious denomination test is not according to the intention of the constitution makers. It is my first proposition. Even a section of any religion, any religious denomination would get freedom under Article 26. Article 26 do not describe that how much followers are necessary to constitute the religious denomination. And how many followers are necessary for their section? For example, the Dalai Lama is a political asylum in India, and he represents the Tibetan Buddhist denomination. A section of that, and he also gets the full religious freedom in the Dharmsala by the Indian government. It is also the reality. And also, like Lordship, there is a Yazidi religion. They are a minority in the somewhere in the northern Iraq, and they follow the peacock god. If tomorrow Indian government give to 10 or 20 families of the Yazidis the political asylum, they are the section of their religious denomination. They will also get the freedom of Article 25(1) and 26 both. Now, Lordship, under Article 26, there is no discrimination in different religious denominations. And also our constitution do not make any category of gods in Hindu religion. In Article 26(v), I will point one thing more. To manage its own affairs in the matter of religion, right to manage includes right to decide their modes of worship. Right to manage also includes who will enter, and right to manage also includes right to express their belief and faith collectively. Now, Lordship, one thing, the essential practice, so far as the essential practice doctrine is concerned, it should not be. Because in Article 25, 2A non-essential practices are already given. One. Now, Lordship, one thing. I will give the answer one by one in 2 minutes. All the.
You almost summed up 1 minute.
Lordship, one thing. Please. Lordship, we are waiting since 4 weeks, so please. In Article 26 is not subject to other articles of the Part 3rd, including Article 25. The rights of any individual under Article 25(1) cannot supersede the rights of any religious denomination or any section thereof protected under Article 26. It is right. Now the scope of Article 25(1). All persons are equally entitled for freedom. All persons include citizens and non-citizens both, foreigners visiting India, diplomats living in India, refugees in India, all the categories. Dalai Lama is also political refugee, which I mentioned. That means Article 25(1)(a) also clears that the religion always have the international feature. We cannot restrict it only in India. Scope of Article 26.
That is why it is part of religious tolerance.
Yeah, absolutely, Judicial.
What is part of religious tolerance?
Tolerance. And now the scope of Article 26. It is available to the followers of that religion also, which originated in foreign, but its religious denomination or any section thereof is in India, like the Islam or the Christianity. If Islam and Christianity have 2, 4, or the 5 religious denomination. If 50, 30, or the 60 families of that religious denomination are residing in our country, then they will also get the protection of these articles, because we have to emphasis on every word. Any section of thereof is specifically mentioned in that. Now, Lordship, question number 4. It is clear under Article 25 and 20.
Yes.
Under Article 25 and 26, morality does not include constitutional morality. It is correct, because it is discussed, but even then it is not mentioned. Religion, customs, and traditions are also the source of morality. What is morality? Morality includes the high values of life, character, and conduct. Service of mankind is also morality. For example, the Florence Nightingale services to the wounded soldiers in the relief camps during war is also the example of the morality. Like as the William Shakespeare's famous lady character Portia, appeal of mercy in the trial scene of courtroom is also the example of the morality. And also in Hinduism, like as we can say, the sarve bhavanta sukhne, sarve santu niramaya, sarve bhadrani pashyantu ma kashchit bhag bhavet. That is the prayer to welfare of all is also the example of morality. And now in Islam, in Arabic, Salam means, Lordship can understand, salam means peace. Yeah. Yeah, Lordship. Sorry. Lordship, the salam means peace. And Islam means the way to that peace. How to get that peace? There are the five pillars of the Islam: kalma, namaz, roja, zakat, or hajj. I will point out only on zakat. Zakat means charity. That means donation to needy. That is also the morality. Live and let live. Jio or jeene do. It is also the morality, apart from speaking truth, benevolence, etc. Now, Lordship, in judicial review, the constitutional explanation of Article 25 can be done. Besides any state law, concerned with Article 25 is also subject to judicial review. This Honorable Constitutional Court is the custodian of the Constitution, so there can be no limitation on the power of judicial review. It is the inherent power because it is also the basic structure. Now, what is the extent of judicial review? It should be in such a way that the spirit of religious freedom would be maintained. Now, the section of Hindus in Article 25 to B is based on caste. Everyone says, because caste is the integral part of the Hindu religion. It is not gender based because gender is in every religion, but the caste is only in Hindu religion, because we have to give the reason why it is so. So that's why. Now, Lordship, question number 7. The belief, faith, and worship. Three things: belief, faith, and worship are protected in preamble. And also in Article 25(1), when we say the concise, the belief and faith and worship in do practice and profess. And in Article 26B, I also explained, of the Constitution of India. It is not the subject matter of logic and science. So a person not belonging to a religious denomination or religious group cannot question the practice of that religious denomination by filing PR. For example, it may be the question that who has seen the God? That means no God, no religion. But the fact is that the existence of God remains in the belief and faith of the followers. Now, Article 26 is not subject to other provisions of the Part 3rd, including Article 25. We should not make the complex synonyms or the complex analogies to create the problem. We should give the simple reading of the articles. What the Constitution makes us say, all things are written in the 25 and 26 clearly. So far as Article 394 is concerned, authoritative text in Hindi meaning is concerned, it was injected by the 58th Constitutional Amendment Act in 1987. Constitution was written before 1950. Religion is the international feature. It cannot be lots of within 1 minute. I will conclude.
1 minute.
Religion is an international feature, cannot be confined to one nation or one language. Even English has distinction of international language. To understand the original and real meaning, we have to give the effect of English version. So that's why, nothing more. Now, Lord, say one thing. How the rights of deity or ideal protected in the Constitution? Many are said that the Pran Pratishtha ceremony, juristic person, deity eats every day in the form of bhog, or he sleeps every day in the form of Sayan. He is the living entity and also the juristic person established by the court. But the rights of deity is protected by the customs, tradition, priests, and the followers. And the right of these followers are protected by Constitution under Article 25(1) and Article 26. Thus, the rights of deity are indirectly protected by the Constitution. Not directly protected, they are indirectly protected, because the deity will not say anything. The followers will say that how our deity will do something, or what the tradition, what the custom wants. Now, Lordship, at last, one thing. In Sabrimala temple case, there is no violation of Article 14, 15, 17, and 25. There is no ground of age in Article 15, and it is last one thing. In Hindu religion, temple is a place of worship. It is not a picnic spot or the tourist place where everyone can go without following the custom or the tradition. For example, a person comes to this honorable court with a prayer or with a request that I want to go the worship place wearing the shoe.
or for the midnight visit in the temple, while the custom and tradition are not allowing this. Whether the court will allow? Not at all, Lords.
Yes, Lord.
It is.
Got it.
Thank you, Dr.
Grateful,
Thank
Lords.
you. Thank you very much. Thank you. Anyone,
Lord,
is there anyone, Mr. Gaurav Kumar? Anyway, Mr. Sai Shashank? Madam Prachi Bajpayee? We were oh, done, yes, done. And A. Shima also done. Yes. Yes. Already. Now, Mr. Nedampura, you
Yes,
are
my
arguing
lord.
this side.
Now it is 4:10.
You are arguing the.
No, for the petitioners, for review petitions. Mine was the first review petition. Mine was the first review petition seeking review of the Sabarimala
10
judgment.
minutes.
My lord,
10
now
minutes.
I need some time.
Everything in Latin terms?
No, my lord, I will not say a word which others have dealt with. Now, my lord, I am raising certain theoretical issues, fundamental legal issues. Now, my lord, the other day I came across with a judgment in Eminent Colonizers Private Limited. At paragraph 24, it is said, a judgment in Rum act as a precedent. And my lord, there are other, it is based on a Latina of the judgments. Number judgment in Rum constitute a precedent. What is a judgment in Rum? What is a judgment in personam? Now, these terms have been very widely misunderstood. The Chief Justice, Honorable Chief Justice knows the case of K.S. Varghese. In K.S. Varghese, the dispute was about 3 churches, Kolanjeri, Varikoli, Mannatur. The suit was a representative proceedings. And the judgment, being a representative suit, will bind the parishioners, the trustees, and the 3 churches, Mannatur, Kolanjeri, and Varikoli. And the Justice Arun Misra in his judgment in K.S. Varghese said, since the suit is a representative proceedings, the judgment is one rendered in Rum, and that will be applicable to all churches. And what followed was literal revolution in Kerala, literal fight between the 2 Orthodox factions and the Jacobite faction. And all of the judgment in Rum is not a judgment, it does not constitute a precedent. What is the distinction between a judgment in Rum and in personam? A simple example is in a suit for divorce, where a judgment is, divorce is granted, the judgment is in Rum. Where a divorce is declined, the judgment is in personam. So, my lord, the fundamental principle of law that res judicata, you are bound by a judgment, right or wrong. Res judicata pro veritate accipitur. It is founded on 2 principles. Interesto republico ut sit finit litium. In the interest of the republic, there shall be finality of litigation. And second principle, my lord, in public interest. Nemo dabet bis vexari pro uno et idem cosa. No man shall be vexed on the same question more than once. So, a erroneous judicial decision, Ulpian said one of the words of Ulpian, res judicata facit ex albo nigrum, ex negro album, ex carvo rectum, ex recto garvum. So, a judicial decision can make white the black, black the white, straight the crook the straight. So, a judgment in Rum is not binding on the whole world. Now, I am asking you the question, coming to the jurisdiction of this court. Your Lordship, the 9th Constitutional Bench of this court passed a judgment. And as somebody who believes in basic jurisprudence, I would say that, my lord, your Lordship will not bind me. I am not a party to the proceedings. The doctrine of rescinder alios acta, altori, nasari, non debet. So I am not bound by your Lordship's judgment. I will not obey your Lordship's judgment.
Either you argue in English before us, or you will argue in Latin.
No, I will argue only in English. I will translate.
Yes.
I will translate.
Yes.
So therefore, my lord, the question is, your Lordships, the greatest respect, your Lordships have no jurisdiction to render a judgment in a proceeding which I am not a party at all. Why I say this is because, my lord, if the issue, assume there are believers and there are believers who believes that the restriction is a mere superstition, and there are believers who believe that it's a core of the faith. Assuming that's a conflict, there is no conflict. Assume that there are two groups of people, and such a there was in which case there is a list, and whether the belief is right or wrong, no court can decide. There's a technical, theoretical reason for that. I'll come to that. Now, if such a dispute is there, whether there is a belief is or not, and if there is a belief and there are two factions, we have different point of view, like in the church case, then such a dispute can be decided only in a representative proceedings. In a suit duly constituted involved under section 92 of the CPC, under Order 1, Rule 8, CPC, their suit is conducted as a representative proceedings, and the judgment acts as a residuicata. It binds all. So therefore, there are two judgments here. The judgment of the 5-judge Constitutional Bench. The other is a judgment of a Kerala High Court in C. Mahendran's case. In my humble submission is, both the judgments are rendered void ab initio, because those judgments were rendered without notice to the devotees at large. So therefore, now otherwise I would have said Article 32 petition could not have been maintained when there is a judgment which is otherwise binding on all. So the Mahendran judgment is not binding on anybody, because it was on a writ jurisdiction, it was on a PIL. Now the question is, we talk about judicial review. I certainly, my lord, I adore the concept of judicial review. But the foundation of judicial review is the principle. In many other countries, America and all the Commonwealth countries, the concept of judicial review is very much there. But the validity of the judgment is solely founded on the fact that the judgments of the court, my lord, receive so much of respect and adoration, and it is accepted out of reverence, not because it is residuicata. I take a drop of water. Now, it is therefore judicial. When I challenge a statute before your lordships, and your lordship declare this statutory provision or statutory instrument unconstitutional, the people of this country accept it out of reverence. It is not because it is binding on those who are not parties before the court as residuicata. Now, the fundamental principle is, I am not bound by a judgment of which I am not a party at all. The reason is, it is against the first principles of natural justice. In a proceedings where I had no opportunity to address the court, adduce evidence.
Please go to the next point. We have understood your
Yes. Now, the second ask, yes. So therefore, my submission is, the judgment in Shabarimala case, 5-judge Constitution Bench judgment is one rendered void ab initio, and it is liable to be recalled, reviewed ex debito justitio. And that concept is, my lord, when I learned first thing about certiorari is, my lord, where certiorari is, where an order of a tribunal is without jurisdiction, then writ of certiorari is granted. That is I learned in 79. Ex debito justitio. So therefore, the review petition is liable to be allowed. I am only speaking about Shabarimala, for which alone I am authorized, as one which is rendered void ab initio. The second proposition, I will be very brief. The second proposition I have here before me, the lordship's judgment. When my lord, yes,
please have water. You missed to know that in your water bottle there was no water. It was empty.
Yes, there was no water. Yes.
Water bottle. Please have it.
I'm grateful to your lordships. So Tirumurthy, Fragrances Private Limited, where my lords, Justice Suryakant, Chief Justice, and Justice M.N. Suresh, Sundaresh, both were parties. And there their lordships have taken a view that numerical strength is the determinative factor. My lord, I have a right to dissent. My lord, what is a precedent? Is a principle which a court of competent jurisdiction, superior court has evolved, where none existed, and or where for a resolution of issue which was before it, or a principle which has been repeatedly reaffirmed. So precedential value of a judgment is the principle and not the numbers. And it is in contrast with the res judicata. Res judicata, my lord, a bench of 5 judges calls an innocent man guilty of murder, sentenced to death. He is innocent, but because the court has found him guilty, he will be hanged. So therefore, an erroneous decision, right or wrong, is binding. And where the matter is, if there is a division of the bench, what is determinative is the relative strength, the majority, numerical strength. That is what is applicable to res judicata. And when it comes to the question of, my lord, the precedent, the number does not matter. Now, this in all over the world, except in India, and it has been noted in paragraph 44 in Andule's case, that we follow a new jurisprudence where the precedential value of a judgment is determined based on the strength of the bench and interstate strength of the within the bench. So therefore, that is absolutely incorrect. Why I emphasize on this, my lord, in all humility, I consider many judgments, the greatest respect of this court, constitutional judgments are fundamentally wrong. The first judgment in Keshavananda Bharati, in 3 sentences, my lord, I can convince your lordship how flawed it is.
We are not on
No, because Keshavananda Bharati is referred to in many, only 3 sentences only, my lord. These are fundamental things, fundamental things. Keshavananda Bharati's case.
Please confine to the issues.
Yeah, I am only on this issue. Only on this. I am only saying 3 sentences. The world is interested to know 3 sentences why the Keshavananda Bharati judgment is flawed. Before Keshavananda Bharati, my lord, ibi just be remedy, right remedy forum. When I come before your lordship would ask, then why are you here? I will have to plead violation of fundamental rights. After Keshavananda Bharati, I would come to the court and say, my lords, none of my fundamental rights are infringed. And what the basis structure? Because of the reference to the judgment of the Keshavananda Bharati, your lordship will not ask me if the basis structure has crushed. How come it mattered to you if none of your rights are infringed? So therefore, my lord, Keshavananda Bharati opened the gates of this court for, my lord, busybodies to come, for somebody to come to approach this court that none of my rights are infringed, and without complaining any violation of fundamental rights. My lord, is a scenario which is most unfortunate. And my lord, in Ecological case, the Nigerian Constitutional Bench tried to undo some of the mischief arising out of the Keshavananda Bharati by saying that fundamental rights is also a basis structure.
We understood that. Next point, Mr. Nehru.
No, yes, my lord, now, my lord, the whole question is, PIL. PIL, my lord, pro bono litigation, absolutely legal. Somebody is in jail. I take up his case. The A in jail, he is the petitioner, not me. Maybe Matthew Numbara versus Union of India may be the title, but the man in jail, the under trial, whose cause I take up, he is the petitioner. Therefore, that is constitution. There is a person aggrieved. He is entitled to remedies, and there is a forum, right remedy forum. On the contrary, the public interest litigation is all about stepping in the shoes of the Attorney General, who is the sole representative of the public interest, sole custodian of the public interest, parents patrae. So every PIL petitioner is a Attorney General. And my lord, there are some cases PIL has done some good. But today I raise this issue because PIL has become a great mischief. Issues concerning the public at large are decided behind their back. Many instances, because when I raised this issue, I raised the cause of the merely 4 or 5 lakhs of slum dwellers in Bombay. Your lordship may not know, Krishna's book of the bench speaks about a PIL instituted by Bombay Environmental Action Group. Behind the back with the slum dwellers, an order came to be passed to demolish all their shanties. And my lord, 4 lakh shanties were demolished. It happened in Bombay. I came to Bombay as a station lawyer. My lord, all ex parte orders were passed directing these slums to be demolished. Committees were constituted, appointing the chief secretary, police commissioner, and to give report to the court. And my lord, any number of petitions were filed. It was never received. One finally, I took, my lord, I believe in constitution means, not democratic means. But as a last resort, I organized slumberless ladies in 5 buses, made them enter one by one to the courtroom of Justice Oka. And that was the end of the torture of the demolition of the slumber list. My Lord, therefore, my Lord, I am not saying that, my Lord, your Lordship should absolutely shut your doors to the PAL, my Lord, if something good. But PAL is something to be kept in mind is completely without jurisdiction. And my Lord, all that, if somebody comes with a, my Lord, seeking any of this in the nature of mandamus, quick time proceedings, where public authority has failed to discharge its function, certainly, yes, for which we don't have to say it is a PAL. Now, my Lord, my Lord, I may be forgiven. My Lord, I'm a critic. I'm a bona fide critic. I've been working for the last 20 years for judicial reforms. My Lord, this is sad that, my Lord, SLPs are dismissed in a few seconds. We need to hear the common litigant. Common litigant, now my Lord, this bench, my Lord, I'm not blaming anybody, my Lord. With the folded hands only, I'm saying this. My Lord, no, only one sentence.
Can ask you
only 5 courts were closed.
the way you are.
No, 5 courts were closed.
Outside the court halls.
So, my Lord, so many.
Concentrate on the subject or close your arguments. This is not a forum for all this.
Yes, my Lord. Yes, my Lord. Now coming to Ayyappa, coming to Ayyappa, my Lord. These are all things. The grievance of the people. My Lord, with the folded hands only. These are all the.
You have made enough real social media.
My Lord, now the coming to the Ayyappa, Lord Ayyappa, my Lord. Now, my Lord, now there are certain religious beliefs which may, in a sense, be violative of the equality clause of the Constitution. I'm a Christian. Syrian Christian. Many practices we follow are discriminatory of women. And there the court cannot step in. Any reform has to come. The reform has to come from within. And then, my Lord, my Lord, tomorrow the Ayyappa devotees, ladies, come forward and said that this shrine should be open to us. Certainly, my Lord, that will happen. And all that I know that, my Lord, not a single devotee exists. All the lady devotees, my Ayyappa Devotees Association, my clients are all ladies. They all believe that this is the ordained of Lord Ayyappa. And, my Lord, it is the duty of the court, my Lord, to protect their belief. Until and unless, and in so long as there is no counter argument that until and unless at least a few women come up and say, yes, we want to go to Lord Ayyappa, and it violates our fundamental rights. Yes.
Can I have 2 minutes, my Lord? My Lord, not more than 2 minutes. The temples in Kerala are different from temples in other parts of the country. There is a mythological story behind that. Parashurama threw an axe from Gokarna, which fell near Kanyakumari, and this land came to be called as Kerala. My Lord, he had 2 tasks before him, one to make the land fertile and another to make the land holy. To make it fertile, to desalinate that land, my Lord, he invoked the blessings of Vasuki, the serpent king, who spit venom and made it fertile. And the other aspect is to make the land holy, he consecrated 108 Shiva temples and 108 Devi temples. My Lord, as far as the Kerala temples are concerned, Chaitanyam is infused in it. Divinity is not inborn. You can close down a Balaji temple in Tirupati or Sri Rama temple in Ayodhya for a week and reopen it thereafter. Divinity will not be lost. But as far as Kerala temples are concerned, unless the religious practices and tantric rituals are continued daily, my Lord, the divinity will diminish. So that aspect of the matter may kindly be borne in mind.
May I submit, my Lord, the argument notes? Okay.
इसको छोड़ो तो बोल रहा from respondent side. So to commence the argument or to respond. Madam Mitra, you will start tomorrow.